Yes, madam.
With your lordship.
Hmm.
This is an matrimonial appeal matter as well pending since month of February, and she has not getting in payment. A matter may come up on order on Tuesday.
Yeah. What is that?
Pending matter.
Pending matter.
Payment order. She hasn't been get payment till the month of February. Matter may come up on Tuesday.
No, what matter is it? Appeal?
Matrimonial appeal matter. MAT.
Matrimonial appeal.
She has not getting any payment since
for-
the month of
Okay.
January.
Okay.
So matter maybe come on next
It
Tuesday.
should come on orders or admission?
Orders.
Orders. Okay.
Please would like to mention item 9 on today's list. But you will pay for reposting on some other day. Item 7 on the list may take some time. Don't you? We'll prepare that money.
How do you know? They might adjourn it also.
Don't you may
When do you want it? 2 weeks?
you may also perhaps fix a hearing day in July.
July.
16th. 16th or the Thursday. Any Thursday.
Yes. Can we have a date in July? Let's wait for by the Learned Council for the appellant. Not objected by the other side. Matter stands adjourned to be listed again on.
But you, the amicus is not available on 21st. There's an amicus in the middle. But you 23rd or 30th.
Not July only.
Yes.
On 30th of July.
Yes, sir.
30 July.
Oblige.
Lordship, I get to my flight number 11.
Yes.
Lordship, kindly adjourn for the day. Lordship.
Why?
Lordship, my senior is out of station.
H.R.A. Chaudhary. Who's out of station?
Mr. P.
P. Mahanta. He is the conducting counsel. Okay, the conducting counsel, Mr. P. Mahanta, is to be out of station. On a prayer made on his behalf, matter stands adjourned for the day.
After 3 weeks.
Matter will be listed again after 3 weeks on a date to be fixed by the registry.
May I please, your lordship, I recommend item number 12.
12.
Lordship,
12.
12.
It's a supplementary also. Fast.
See, my senior MD, Mr. B.B. Waterquist, 1 year old baby, is suffering from higher fever. So, lordship, matter may be fixed after 2 weeks.
PP Botago.
B.B. Waterquist.
High fever.
It's 1 year old.
Oh, baby's fish. Okay, high fever. After 2 weeks, you say. Anyway, it's listed for orders. We'll see once the matter reaches. Sorry?
Once you guys are, I intend to get.
Okay, we understand. Let the matter reach. We'll pass the order as and when the matter reaches. Okay. What is your good name? K. Gogoi. Okay. Yes.
Prohibition item 1.
Yes, Shomoto, this one just to monitor the. Your lordship kindly see the last order. That is 7/4/26.
Hmm.
In pursuance to that order, all the state has to file their respective affidavit giving the latest position of the how many members they have released.
Okay.
That was the last data your lordship has. And
With effect from 2nd of April.
My lord.
Any updates?
My lord, till now, my lord, no affidavit.
No, my lord, there is no release from the February till now. So we did not file our affidavit, but we can file the affidavit saying that there is no. So I'll.
Yes, we file. We'll post it again after, I think, some time. We don't know. Oh, I see. Today. What does the affidavit say? Speech are.
Already 3 convict were released after last order.
I see. 3 more as this. And Arunachal? Okay. No release, but you'll be filing an affidavit. Okay. When should we list it, Mr. Manta?
Let them file an affidavit and then we will release this. That's only my lord to monitor. My lord.
This is in terms of the apex court's
Apex
decision,
court, my lord.
direction that suo moto PL should be registered
Yes.
to monitor this.
Monitor this,
Ah.
my lord, how does matter, my lord, remission has been granted?
Since it's monitoring, we cannot close it also.
No, no,
So
that's
we'll
monitoring.
post
It
it
has to
again
be,
after
my
2
lord. It
weeks
has to be,
perhaps.
my lord.
We'll
has
post
to
it
be,
after
my
2 weeks.
That-
After 2 weeks.
Like switch.
All right. Heard Mr. T.J. Mantal and its senior counsel appearing for the. You are the standing counsel also.
What?
Senior counsel and as well as the standing counsel of the Gauhati High Court for the petitioner. Also had Ms. P. Bachaj, learned additional AG, Mizoram, who submits that additional affidavit has been filed.
State of
Pursuant to the order of this court dated 2/4/2026, and she submits that as regards the updates, three more convicts have been released on remission since the last court date. Stop. Ms. T. Crow, learned additional AG, Nagaland, submits that as far as our instructions are concerned, nobody has been released since the last court date, and if so required, she will file an affidavit to that effect, and for which she prays for 2 weeks' time. Then Mr. A. Chandran, learned senior government advocate, Arunachal Pradesh, submits that he'll be filing the affidavit during the course of the day. To stop, he also submits that the status of, in case of the state of Arunachal Pradesh, is that no further release has been made since the last court date. Next para, since this PIL has been registered as a suo motu PIL pursuant to the direction of the apex court for monitoring and supervising the implementation of the remission and premature release policy of the states of Assam, Nagaland, Mizoram, and Arunachal Pradesh. The matter shall be posted again on a future date for further updates. Next para. Accordingly, let the matter be listed again. I think just before the vacation,
But
on 25th of June 2026, the parties will be at liberty to file their affidavit for further updates.
oblige.
For orders, I didn't.
May Lordship, produces the office note of 2nd of June, Your Lordship.
6th of June, 6th of May,
2nd of June.
2nd of June. Notice has not been affected. How much time? Office note dated 2/6/2026 indicates that copy of the notice to be served upon the respondent number 2 has been handed over to the office of the additional PPSR for the needful. Stop. Mr. R. Kaushik raised for and is granted 2 weeks time to get the status report
Your Lordship,
regarding
here is
service of
the
notice.
childhood record just come, Your Lordship.
Since PCR has come, office to prepare the paper book. In the meantime, list again after 2 weeks. Yes.
Oblige, Your Lordship.
Item 3. Lordship, we have got the service report. paper book is also, will they file objection if it's signed?
I have not received the paper book.
I what? Maybe three numbers, maybe his copies.
How is it numbered? PB1, PB2, PB3 like that? Yours is what? Oh, cost list.
Yes.
Okay.
PB three. So. his
PB3 means?
Paper book, three copies are there, the paper book.
No, that's correct. But why is it indicated like that?
Maybe he has not, since he hasn't received any seat, no?
Okay.
He's not received it, so,
If the
Obviously.
same is not received, it is indicated in the cost list,
yes.
PV3. So you have to collect it, I think.
Yes.
So here also you can do.
Or you can take it from him.
No, is to observe in the order.
This is what notice? Notice.
Yes. Signature of the, this one is.
What is this? POXO matter again?
Yes,
It's a
ma'am.
POCSO matter.
Okay. This B. Bhuya, learned additional PP, Assam submits that notice has been served to the respondent number 2. Stopping support of our submission, she has produced copy of the acknowledgement reported by the officer in charge of Kharupetia police station. Stop according. Respondent number 2. Anyone appearing? No one.
It is a-
We appoint somebody.
Yes.
Since no one appears for respondent number 2, we appoint. Yesterday, how much will be? You got an offsetting. We appoint Srimati Anushmita Sharma as the legal aid counsel to represent respondent number 2. Registry shall provide the paper book to her within 3 working days. Mr.
Lordship, M. Ahmed.
M. Ahmed, learned counsel for the appellant,
Yes.
submits that he has not received a copy of the paper book. Stop. No, not stop. Whereas Ms. B. Bhuya, learned additional PP, Sam submits that she has received a copy. Stop. It is seen from the record that the copy went for the appellant is available, and therefore the same is handed over to the learned counsel for the appellant today. Stop. When should we list it?
Can it be listed just before vacation, Lordship, because there is a prayer for bail, Lordship?
Lordship, main hearing, it will take some 2026 matter. But IAP wants to press for it, then Lordship
be
will
just-
fix it.
In this
But
month,
main hearing, Lordship may not, because it's 2026 matter.
Next, learned counsel for the appellant submits that consideration of the appeal will take some time, and therefore he prays that the interlocutory application seeking bail may be taken up at an early date. Considering the same, let the matter be listed on 23rd,
23rd.
yes, of June. Have you filed an objection?
Yes.
Okay.
I think 12 of the appeal is.
It's a-
You wanted some time.
Yes.
Will grant. Ms. K. Gogoi, learned counsel appearing on behalf of Mr. P.P. Botaku, the conducting counsel for the appellant, submits that since Mr. K. Gogoi has some personal difficulties to appear before the court today, she paper book you have received?
People put sign, it might not be-
Hmm.
No, we have received, we have.
It is also noted that the paper book has been supplied to the learned counsel for the parties. As prayed for list again after 2 weeks, or a date to be fixed by the registry.
13 and 14.
What is this? Oh. 14. Now paper book is read in 14. 13 TCR was not there. So somebody submitted that I think the trial court said that TCR is already sent. So this case involves two persons. Both of them have been convicted. So I think who appears for 13? Anyone?
SN Tamuli.
Listen, Tamuli. What did he appear last time? No, I understand. Dismissed. What is your prayer now? Okay. See, one thing is that the paper book can be common for both the cases.
Yes.
Item number 13 does not have any paper book. So we can,
Still the paper.
you have not received. In item 14,
Lordship,
14,
it's not provided to us, so the meeting.
14, you have not received.
Lordship, it's not available.
Anyone has received paper book?
No, we have received lordship. For item number
But-
14, we have received.
But PP should have received also.
Our office, generally they receive it, my lord. But lordship not provided to us.
So you check it back from the office. Now, what we are saying is that since the item number 13 also relates to the same judgment, it's a common judgment. We can have a extra copy of this and give it to the party concerned in the item 13,
Yes.
and it will serve the purpose. Because no separate paper book is required to be prepared. Same thing can be relied upon. Nobody is there in item 13. Please write, both these matters have been clubbed together in terms of the order dated 22/4/2026. Stop. When the matter is called, no one appears for the appellant in criminal appeal number 7 of 2026. Stop. However, the appellant as well as the state. What about respondent number 2? And respondent number 2 in criminal appeal number 342 of 2024 are represented. Stop. It is noticed that both these appeals arise out of the common judgment passed by the trial court. Judgment in trial court in POCSO case number 295 of 2023. In connection with Jagi Road PS case number 229 of 2022. Stop. Since paper book has already been prepared in criminal appeal number 342 of 2024. Stop. Registry is directed to prepare to multiply the paper book already prepared for use in criminal appeal number 7 of 2026 and furnish the same to the parties concerned. List the matter again after 2 weeks.
Lordship, what people who to all the parties? Because evidence would be the same, your lordship, just
No.
the same.
One paper book for one counsel. You want to share?
They have already received.
Nobody appears for item 13. So
14 they are appearing. 14. Yes, 14 would cover 13, madam.
that is why,
Yes,
but that counsel should be also given a copy.
they're not there.
Tamuli or Zanat or P. Deka, whoever.
If
They'll-
not
they will-
already received,
They will get a copy.
if not already received.
I don't think they have received because court has directed to call for TCR. Then the judge says that TCR is sent already in item 14. Item 14 paper book already made. So we'll make photocopy of this and give this paper book to the counsel for the item 13. What is the last line? 2 weeks. On a date to be fixed by the registry. Is it not? No. Hmm. It is also made, it is also provided herein that if the learned additional PP Assam has already been supplied a copy of the paper book, uh, uh, furnishing of another copy would not be necessary.
Fine.
Okay. You may have received, not required, you don't require two paper books. All right.
Item 4.
Yes, who's there? Appellant, you are there. What is this matter?
It's an appeal against an acquittal order.
Acquittal.
Acquittal.
You are the,
I'm for the.
You
I
are for
was
the appellant.
informant. I was the informant. The accused got acquittal. We have come up against the acquittal order.
you are the informant. Okay. It's a case of 302.
It's a case of.
Then who are the other parties? PP is there, then who else? Mr. Manta is for? Accused. Okay. There are three parties in all, is it?
Yes, three parties.
Three parties. Hmm. Informant, state, and the accused. Hmm. So you all are ready?
Not sure if I can start.
Okay. Yes.
So, not sure what had happened in this case is
Hmm.
the FIR was lodged in 2012. My main challenge in this order is regarding a dying declaration. So there was a dying declaration. So the persons who has been deceased, the deceased before dying, he said the names of the accused persons who inflicted injury on. And those accused persons later on in evidence, they stated that they have come to know it from the person who has passed away, that these persons are inflicted injuries on his body. Later on, that person succumbed to his injuries. So I will take your lordship to the main evidences.
FIR is dated 22,
Yes.
20 February,
22 February
February 2012.
12. That is in page number 11.
Your cases of dying declaration.
Dying declaration.
This was not,
The dying declaration was not taken.
not accepted by the trial court. Okay.
Page number 11 of the paper.
FIR. Yes.
So the informant, Mujahidul Islam, that is B, that is PW1. Lordship will see the accused person number 1, Haja Alam, that is the respondent. There are other accused persons also who were also acquitted, but I have come up against appeal against acquittal only against Haja.
Khaja Alam.
The trial was for 13 accused persons, 13 got acquittal, but I have come up against this one person.
Khaja Alam is accused number?
He's the accused number 1 in the FIR. And he's the sole respondent.
In the trial also?
In the trial.
Accused number 1.
Yeah, one of the accused. The numbers are not there.
Numbers are not there.
Numbers are not there. One of the accused.
One of the accused. Where's the judgment? Otherwise, page?
Judgment is page 120.
150.
Yes, not sure. He's accused number 1.
Oh.
But that states about the FIR. All were acquitted.
Khaja Alam. Yes, please read FIR.
Operated by in page number 12. I have the honor to state that at about 11:58 p.m. on 19/2/2012, that is late night, when my elder brother, Moinul Islam, was watching Janata Party drama in Mumbai theatre held in Nandini Dharmani village, the aforesaid accused number 1, that is the respondent accused person, called him out to discuss something.
in a planned way and in furtherance of conspiracy. While they were going towards Patanipuri by the bike belonging to Moinul, the aforesaid accused persons equipped with weapons lowered Moinul Islam down from the bike and caused grievous injuries to him by repeatedly assaulting him with sharp weapons. Now, this is important. Having learned about the incident, we rushed towards the place of occurrence and got to know the names and addresses of the accused persons from him, Moinul Islam, in his injured condition. Though we immediately took the injured person to the Morigaon Civil Hospital, he succumbed to his injuries on the way. So here also from the initiation, he states he got to know the names from Moinul Islam who succumbed to his injuries. The accused number one is Khaja Alam. That is what the FIR states. Then, Lordship, if I can take your Lordship to the evidences. Then later on, charge sheet was submitted, charges were framed against all of them. PW1, page number 24. There are a total of 9 witnesses, but the main witnesses who heard the dying declaration, 4 witnesses are there. PW1 is one of them. He's the informant.
Dying declaration, 4 of them.
4 of them. That is PW1, PW2, PW3, and PW6. These
What?
are main witnesses.
1, 2, 4, 6.
1, 2, 3, and 6.
1, 2, 3, 6.
So PW1, that is page number 24. If I may read.
Yes.
Page number 24. The accused person. Disease Moinul Islam is my brother. I have filed the Ejahar. Occurrence took place about 10-15 months ago at about 12 midnight at village so-and-so. At that time, I was enjoying Jantra along with my brother Moinul Islam at our village. Idris Ali, Isadul Haq, Joinul Amin along with us. These are PW 2, 3, and 6 with us. At that time, Moinul told me that he received a phone call from Khaja Alam and called him. Then Moinul went out of the Jantra pendal and he was taken by Khaja Alam in his bike. After 10-15 minutes, we have heard some hue and cry, and then we came out of the Jantra pendal towards the road. Then I saw Khaja Alam, so-and-so, these are the other accused persons who are not in this appeal also. Armed with dagger, dao, pointed vehicles, and my brother Moinul Islam was lying by the side of the road with injured condition and pool of blood. I saw cut injury on the forehead, face, back of Moinul, and while Moinul saw me, he told that Khaja Alam and the others, he has taken the name of other persons also, but he has taken. So here, basically, I'm concising my argument only on Khaja Alam because he's there as the respondent. Khaja Alam and so-and-so caused injury on his body. Idris Ali, Isadul Haq, and Joinal also present with me. So here, Lordship, the main thing is, he went there, he asked who caused you injury, and he specifically stated so-and-so are the persons who caused injury upon me. And this PW1 also states that Idris Ali, Isadul, and Joinal were also present with them. These are the persons PW2, PW3, and 6. So this is the dial declaration that Moinul saw me and he told me that he heard that so-and-so has inflicted injuries. Now the cross portion, page number 25. I'm living in so-and-so village, which is so-and-so kilometers away from Jantamina. Fathers of the accused Khaja Alam is Maharuddin and he was murdered. My deceased brother Moinul wasn't accused in Maharuddin murder case. What had happened earlier, there was a case where Khaja Alam's father was murdered. There was a murder case pending against Khaja Alam's father. There, this Moinul Haq, who is deceased in this case, was accused. So there is an enmity here. So the motive can be established here because the respondent number 2's father was murdered in a criminal case. A case was there. This person who has died, he was the accused.
So why did you go out on qualify and movie?
So that is what,
Why would you go out when you told him?
why was the call made? That is the question.
Informant is the brother of the deceased.
Informant is the brother of the
The
I'm
informant is
the elder
allowed to go when the enemy's son is born.
that is what. But for him, I am the enemy. I am not actually the enemy. Because I was,
They are the witness in that matter.
and they were called, and that's why they called me and I went outside. And if I may take your lordship to page number 25. 7 lines from the bottom. This was confirmed in cross-examination. 7 lines from the bottom, page number 25. I saw persons proceeding from southern side to northern side with arms, and we were going from north to south. So I saw the accused person from front side. All the 9 accused persons were armed with weapons. This was confirmed in the cross. This person, when he was coming out, when he heard the given cry, he crossed them and he saw these persons with armed weapons coming from the place of offense. And in page number 26, third last line. So a suggestion was put to them. That was only a suggestion. It is not a fact that the deceased Moinul told me that the accused person caused injury to him is false. The lordship already know this is not how you put the contradiction. This was only put to him, but it was not confronted with the IO. So a suggestion was placed on record by bringing it. It is not a fact that deceased told Moinul Haq that accused person caused injury to him is false. So what had happened here, the evidence is still intact till now. Now, if this cross is confronted with the IO, it was not stated to him also, then only it emerges. So this is only a suggestion. That can be endless suggestions can be placed to the accused. So this is PW1. So he has stated that he got to know about Khaja Alam from Moinul before he died. So this was PW1. PW2. Adrish Ali.
Who is he? PW2?
PW2 also, he came to the place of occurrence. His name was cited by PW1 himself that I, Adrish Ali, all were present and we went and asked who has caused you injury, how you got those injuries.
No, he's an acquaintance, friend, No,
He
not-
was PW1,
not related. Not related.
not related. Not exactly related, but he was present. So if I may read, I know all the accused person is in Moindul Islam. Occurrence took place about 1.5 years ago. The occurrence took place in Nandini village. On that day, I, along with Moinul, Isadul, Joinal, went to enjoy Jantra at Nandini, so, and arrived at about 9 p.m. At about 11:30, while we were enjoying Jantra, Khaja Alam called Moinul in his mobile, and then Moinul told us that Khaja Alam called him. So he went out to meet him and came out. Then Moinul took his bike. Khaja Alam sat as pillion rider and took them both, went out. After about 10 minutes, we heard hue and cry for about 200 meters away from the Jantra panel. So we rushed to the place of occurrence. Before arrival, about 2 knoll away from the place of occurrence, we have seen Khaja Alam, so all the other persons were coming back with armed weapons on their hands. I carried a torchlight in my hand. With the help of the said torchlight, I have seen. After arrival, this is important, at the place of occurrence, I have seen deceased Moinul was lying on the ground and he uttered to save him. Moinul also told me that he was assaulted by aforesaid persons and he would not survive. I have seen cut injury on his forehead, chin, back, face, near the nose, and on the backside of the head. So here also, this corroborating, same, he went to the place of occurrence, he saw him lying there, he asked him and he uttered to him, he said to him that these are the persons. The first person was Khaja Alam. Again, he has caused injuries on his body. And the injuries have also been stated. He has seen the cut mark, all those injuries he has seen. Here also in cross, it was confirmed in page number 29. 8 lines from the bottom, page number 29. After our arrival, we inquired how he sustained injury and who caused him injury. Then he stated the names of 9 persons. He could not say the details who caused injury by what weapon. So it was confirmed that he has stated the names of the 9 persons. These are the 9 persons. FI also states the name of the 9 persons. Khaja Alam is the number 1. So in cross also, the defense has confirmed that he has stated that. And after hearing from the disease. In page number 30, again, there is a suggestion put, but which only is a suggestion. It is not a fact that Moinul did not tell me the names of the 9 persons who caused injury to them. It is not a fact that at the time Moinul was not in a position to speak. A suggestion was put, which was not later on confirmed. And in page number 31 also, on 3rd paragraph, again it was confirmed in the cross-examination. We have crossed Khaja Alam, so and so. These are the other persons who were coming from southern side to northern side, and they did not speak anything to us. So their presence is also confirmed. When they were coming to the place of occurrence, they crossed each other. All the persons crossed these persons. Then your lordship can come to PWD. See, Shadul Pop. He also heard the dying effect. I know all the accused person and the deceased Moinul Haq. Occurrence took place at about 1.5 years ago. That's so and so. At that time, we went there, Nandini Kumar village, and we were enjoying Jatra. I, along with Moinul, Zaitun, Idris Ali, were enjoying Jantra, which started at 9 p.m. At about 11:30 p.m., Moinul received one missed call from Khaja Alam. I cannot say whether Moinul called back to the person or not to Moinul or not, but Moinul told us that Khaja Alam called him, so he left us and went out from the Jantra pendle. Moinul kept his bike near the pendle, and after leaving us, he pulled out his bike and went towards the road. I have seen that Khaja Alam also went with him on the bike. After about 20-25 minutes, we have heard hue and cry. So I, along with my brother Idris Ali and others, rushed to the place of occurrence. And before arrival, and about 2 knoll away from the place of occurrence, we have seen Khaja Alam, so and so, these persons were coming armed with dao, lucky, and in their hands. So we have seen them as they carried a torch light on my hand, and with the help of the said torch. After arrival at the place of occurrence, this is again important, I have seen this is Moinul lying on the ground, and he uttered to save him. Moinul also told me that he was assaulted by aforesaid persons and he would not survive. I have seen cut mark injury on his forehead, seen cut injury on his backside and on face, near nose, and on the backside of the head also. But he also corroborates that he uttered the name of these persons. Khaja Alam is number 1. In the cross, page number 35, again, their presence that they crossed each other is confirmed. Page number 35. 3rd paragraph from the middle, but if I may read the 3rd paragraph. When Moinul came out of the pendle with his motorcycle, and then he drove the motorcycle, Khaja Alam sat on his motorcycle as a pillion rider. We were watching Jantra while Moinul and Khaja Alam left the place. I went to the place where Moinul was lying by the road, but Idris went to the paddy field. We met Khaja Alam, this is the person, Khaja Alam, so and so, as they were coming from southern side to northern side. While we met the aforesaid persons, they crossed us on the road and proceeded as usual. We crossed the aforesaid accused persons about 2 knoll away when Moinul was lying. Moinul was lying in the western side of the road, about 1 knoll away. After our arrival, we inquired Moinul, caused him injury. Blood was coming out from the injury and stainness also. So it was confirmed, their presence is confirmed, they crossed each other, and then they went to the place of occurrence to ask Moinul from where he got that injury. PW4, later on he visited the place of occurrence, so it's not so important. Now, you can turn to PW6. He's also the one who went to the place of occurrence, page number 43, PW6.
43.
43. He also went there. He was present in that. Yatra. I know the accused person and this is Moinul Haq. Occurrence took place on the road of Nundini in a village at about 11:30, 12 midnight. At that time, I, along with Patrice Ishadul, Moinul Islam, and Abu Tariq were enjoying Jantra at Nandini so and so. While we were enjoying the Jantra, then Moinul Islam received a phone call, and after that, he left us. After about 10-15 minutes, we have heard hue and cry towards the road. At hue and cry towards the road. Then we also rushed towards the road, and then we met accused persons on the road, and they were armed with dao, dagger, etc., and proceeded towards northern side. We go ahead and found Moinul Islam was lying in injured condition by the side of the road. On being asked, Moinul Islam told us that he was assaulted by Khaja Alam, the main person, so and so, and the others also neighbor. Idris called a vehicle over telephone, and we took Moinul to Murga, and after coming kilometers, Moinul died. So here also, the same thing is corroborated properly here. That they went there, asked him, and he stated specifically his name. Here the suggestion, page number 45. The bottom, the fifth line. The suggestion was put to them rightly. It is not a fact that Moinul did not state before us the names of the accused person while he was arriving at the place of hue and cry. It is not a fact that Moinul was dead prior to our arrival, and hence he could not speak, and the fact that he was reporting to us was false. So here, Lordship, we have seen that though in the chief they have stated, in 2 occasions in the cross, the suggestion was put to them. It is not a fact that you have not stated. Now, Your Lordship, the IO, page number 53. So my main witnesses are these 4 witnesses. Page number 53, the investigating officer, IO. Page number 55, the cross, the relevant portion here. The second paragraph, PW1, Mujahidul, did not state before me that Khaja Alam called Moinul over telephone prior to the occurrence. Moinul came out from the pendle and went to Khaja Alam with his bike, and he saw the accused persons with weapon. So this is only the cross-examination of PW1. Though the suggestion was put to PW1, you have not stated about the dying declaration. That was not confronted with the eye.
You had read which portion?
Page number 55, the second paragraph.
Second paragraph.
Second, PW1. This is the cross that was brought on record.
Okay.
PW1, Mujahidul did not state. This is the only part that he did not state before the IO. Before me, that Khaja Alam called Moinul over phone prior to the occurrence. Moinul came out from the pendle and he went with Khaja Alam with his bike, and he saw the accused person with weapons. So even if we take that this part was not stated before the IO, but the part that he saw the injuries when he went near Moinul said the names that these persons caused injury upon him. This was not confronted before the IO. So that remains in evidence. Because that part was not brought to the IO. Before the IO, whether you have stated before me or not. So naturally it was stated before him, that is why that was not brought up. PW2, which also happens to be a witness to the dying declaration, PW2. Page number 55, last paragraph. Idris Ali did not state before me that Joinal also accompanied him to enjoy Jatra. He did not state before me that Khaja Alam called Moinul at 11:59 p.m. He did not state before me that Moinul went out of the place of Jatra on the bike along with Khaja Alam and pillion rider. He stated before me that he went out along with some other persons from the Jatra pendle on hearing hue and cry. The witness did not state before me the name of one of the accused persons, Sohidul Islam. We are not against Sohidul Islam. The witness did not state before me the name of one of the accusers, so we do list now. He did not state before me that the accused persons were armed with weapons. Sorry. The witness did not state before me that after arrival near the deceased, he made shout to save himself. The witness did not state before this witness did not state before me the name of accused Wahad Ali as stated by the deceased Moinul. So here this is important. PW2 in his cross-examination, specifically, it is confronted before the IO. This witness, page number 56, first line, this witness did not state before me the name of accused Wahad Ali as stated by the deceased Moinul. So the other names stated by Moinul were there, where Khaja Alam appears to be. Wahadul admitted, okay, fine. Wahadul, it was not stated before him. The witness did not state before me that he saw injury on his forehead, so-and-so, on his backside, and he did not state before me the telephone Baharul to bring up data. So PW suggestion was put in the cross of PW2, but that suggestion was not confirmed in the evidence of IM. So that still remains only a suggestion one. That suggestion was not confronted with the IM, whether he had stated Khaja Alam's name before the police. So that again remains. PW3, who also appears to be a witness of the dying declaration, page number 56, second paragraph. PW3, Isadul Haq, stated before me that he went out at 11:59 p.m. to enjoy the Jatra. The witness stated witness stated before me that Moinul informed him that he received missed call from Khaja Alam and he went out to meet Khaja Alam. The witness did not state before me that Khaja Alam was going with Moinul on the motorcycle by sitting as a pillion rider. He did not state before me that he went out with his brother Idris after hearing hue and cry, but stated that he came out with some other persons. The witness did not state before me that he saw injury on his forehead, chest, back, nose, and backside of the head. The witness did not state before me after some times of his arrival, Moinul died. They informed police and police also arrived. The witness also did not state before me that he had a torchlight in his hand and could recognize the accused person by forcing of the torchlight. The witness did not state before me that injured Moinul died at Chariali, but stated that he had died on the way to hospital. So here also, PW2 had specifically stated in his chief the names that he had come to know from Moinul. There is no confrontation and there is no confirmation of that statement before the eye. That again remains in the evidence. PW4 is not remembered. PW6, page number 55, 56, second last paragraph. He also happens to be a witness of the dying declaration. PW6, Join Aluddin did not state before me that he came out from the Jatra Pendal at 11:30 to 12 midnight. He also did not state before me that Tejab Ali also with him. He did not state before me that after coming about 50 meters, he saw the accused persons armed with dao, lathi, etc. and proceeded towards southern side. He did not state before me that he came out on hearing hue and cry. He did not state before me that Moinul died at Katiapam Chariali while he was taken to Morigaon Civil Hospital, but he stated that he died on the way to the hospital. So here also PW6, the IO was not confronted regarding the names, anything regarding the dying declaration. So now there is one important aspect, Lordship. There is an inquest report which was done on the same day. That is in page number 173. It was done on the same date, on the date of occurrence, because it was early midnight.
What was the date?
The date was 20.
Incident.
Date of incident was 22/2012. So that would be the midnight, either this way or that way, late night at around 12 after 12.
After 12.
Early
Was it 19?
19 late night.
19 late night, early 20.
Morning.
Somewhere in the PW1, we heard that the next day,
Yes.
that phrase was there. The next day, I registered the FIR.
Yes. So the next date is 28.
Okay.
20. So page number 173 is the inquest.
Yes, what is there in the request?
So Lordship, the main thing is, in the inquest, the injuries that have been stated by the evidences, by the witnesses are the same. There were certain injuries present. But the learned trial court, there is one aspect which was relied in the acquittal order. In the postmortem also, the inquest and the postmortem are more or less same. There were certain injuries found. The postmortem is at page number 159. If I may take you to page 173, the last paragraph. 170 inquest, last paragraph. Now on turning the body into the prone position, a 1-inch long cut injury caused with sharp weapons is found on the backside of the head. There are 3 marks of stabbing caused with sharp weapons on the back of the dead body, and blood is oozing out through the injuries. No trace of stolen semen. Next paragraph. Now, though it seems that Moinul Haq succumbed to the injuries caused with sharp weapons, the dead body is being forwarded to the Morigaon Civil Hospital for postmortem examination. Same day. Again, it was given for postmortem. That is in page number 159. Postmortem report. So there are injuries admitted.
You have not read the second paragraph middle portion. Long deep cut injury with sharp weapons is found both cheeks, chin.
Yeah, these are also injuries found. There are many injuries. Sir.
No, these are the description made by the eyewitness. I mean the dying declarant, the witness who has said that there was a died, they have heard dying declaration.
Yes.
Correct.
But the injuries do match. Certain head injuries, cheeks, nose, everything.
Cut injury in forehead, then seen cut injury on the backside,
On his forehead, long cut injury.
nose, face near nose, backside of head also.
Backside, front side, then the nose, forehead, chin, everywhere there are injuries. The postmortem also corroborates with them. Postmortem report is at page 159. Page 159, page 160, examination 2012 at 2 p.m. At 2 p.m. the postmortem was done. So here also in page 161, Roman 2, scalp, skull, vertebrum, incised wound extending from right temporal region to middle of the forehead with fractured skull. This point there was page number 161, Roman 2, point number 3, brain and the spinal cord. Here, brain matter come out in wound as described. So what was found in the postmortem was some portion of the brain had come out because of the injuries caused. The inquest does not say so about the brain coming out, but here, because of the injury, it was so severe. Some portion of the brain was also visible and it had come out. During the postmortem, he could see that. And he has stated that. The postmortem was done at around 2 p.m. The incident happened early midnight. So in the opinion, injuries, page 163 again. Page 163, Roman 5, injuries, multiple incised injuries in the scalp, lower jaw, right cheek, back, and chest. And the opinion, page 164. In my opinion, the cause of death due to hemorrhage and shock as a result of multiple injuries caused by sharp cutting will. So admittedly, there are multiple injuries caused by sharp cuttings. Now, the evidence of this doctor, which plays a vital part here.
Doctor who conducted the APME.
Doctor who conducted the postmortem.
Page,
That is page number 41, PW5. On 22/2012, I was the Morigaon Civil Hospital as senior medical and health officer. On that day, I performed the postmortem examination of Moinul Islam, 37 years, so-and-so, identified, so-and-so, so-and-so. On examination, I have found the following. A healthy body, average build, with brittle mortars present, eyes are half open. There are an incised wound extending from anterior border of the left stereo, so-and-so muscle just below the chin, about section into 2-inch. Deep muscle and incised wound extending from right temporal region to the middle of the forehead. Brain matter exposed. You could see certain part of the brain being exposed due to the injury. An incised wound extending from right cheek to middle to the lower lip. 2 incised wound over upper part of the right side chest. A penetrating wound over right side of the back of the chest. Next para, there are multiple rib fractures. Right pleura was lacerated. Right lung was ruptured. The left lung intact. There were fracture on the skull bone and multiple fractures in the ribs. In my opinion, the cause of death due to shock and hemorrhage as a result of multiple injuries caused by sharp cutting weapon. The cross portion is important. Cross. This point number 3 that I have shown in the postmortem report, cerebral and spinal cord, second paragraph, page number 42. Brain matter came out in the wound as described. There is laceration in the plaguey right lung rupture. There will be profuse bleeding in such types of injuries. Injury number 2 is situated on the left side of the neck, below the chin. In such type of injury, a person come under the neurological shock. With the profuse bleeding, there is hemorrhage shock. Pleura is a protector of the lung, which protect outside air. Now, this portion, due to exposure of brain matter, a person immediately become unconscious with shock. The person died within 24 hours of the postmortem. So this line, that due to exposure of brain matter, a person immediately becomes unconscious with shock. The trial court relied on this medical finding and hence led the trial court to say that a dying declaration is not believed. Now, my argument is this.
The person died within.
The person died within 24 hours of the postmortem. Rightly, postmortem was conducted at 2 p.m. So within 24 hours, that is last night.
Accurately before the postmortem.
Immediately died. Immediately died. The spot pilot died.
But if you conduct postmortem on a living person, he will die. No, postmortem, the person died within 20 hours of postmortem examination. After postmortem examination, he died. It gives that kind of picture. But what actually went was that 20 hours before PME, he had died.
Yeah.
So calculating that 20 hours, you say that the trial court did not believe the time.
No, Lordship, the line before that. Due to exposure of brain matter, a person, just the line before that last paragraph, due to exposure of brain matter, a person immediately becomes unconscious with shock. So the trial court relied, because during the postmortem, he has said that some portion of the brain had come out, and he has stated in this cross-examination, not in the postmortem report, in the cross, he has stated that if that kind of injury is seen, the person will become unconscious at the point the injury was caused. So that is what is stated by the medical exam. So going by this line,
You pointed out that in the inquest report,
Lordship,
that brain matter was not.
no, the injuries were, all the injuries were there. It was conducted in the same day, just few hours before the postmortem was done. All injuries were there. This brain matter coming out, that was not there in the inquest. But that has come out here. That too, in the postmortem, he's silent about the unconscious part. But in the cross-examination, he has stated that if that injury is seen in a person, then he is expected to be unconscious with shock immediately. The word is immediate. Now the trial court had relied on this particular statement that if that injury is there, he became unconscious, then the dying declaration could not have been said by him. That was the only contention in which the trial court gave acquittal to all the persons. Now my contention is the inquest does not say so, and the medical examiner, it is only the opinion of the expert. When the point he has done the postmortem, that is around more than 12 hours. So that point of time, looking at that injury, he said that it is immediately healed. But was that injury present at the very point of incident?
The
Because-
timing is there.
At 2 p.m.
What 59? Let's see.
Postmortem report is at page number 150, 159, 160, date and hour, examination, 22/2012 at 2 p.m.
2 p.m.
What is 2 p.m.?
Incident happened at night.
early 12 to 1 between that.
11:50.
So now my contention is this is the opinion of an expert. Now, this cannot be said that exactly at that point of time he became unconscious. So there is a conflict between the medical and the ocular evidence. If we go by the ocular evidence, the witnesses who heard the dying declaration which remains in evidence, so he spoke the names, and later on when he was taken, the inquest also says when he was taken to the hospital, he died on his way. And those 4 persons also corroborated that when he was taken to the hospital, he died, admittedly. But when they found him, asked him, they said the names. But this medical examination in his cross, he stated that this injury, where brain is coming out, if that is present at that point of time, then he would be in a state of shock and unconscious. The discrepancy is only that. So the trial court relied on this, the medical cross-examination, that he'll be unconscious. And so if he is unconscious, he is not able to give the dying declaration. So the dying will totally discarded. And acquittal was given. Because admittedly, there is no eyewitness. My whole case remains on the dying declaration. And to that effect, I judgment, Your Lordship, the dying declaration. When can the court rely on the dying declaration? And Lordship already knows the medical examination. That is the opinion of the expert. Court is not binding upon the medical examination's witness, evidence. So the thing is, he can say, seeing the state of the injury at 2 p.m., that he will not be able to speak because he will be unconscious. But at that time, there were 4 individuals who went there, asked, and he stated to them. At that time, they also saw the injury. They all have stated the injuries on his forehead, the cut marks. But nobody has stated of brain coming out or he was unable to. Everybody has stated, corroborated constantly that there were injury marks in his forehead. The inquest also says so. No denial that there were injury marks. But the brain portion coming out was not stated by any of the evidences, any of the witnesses, not even in the inquest, but in the medical it was stated. So this judgment is upon the dying declaration. So that is my case, Lordship. Because the trial court discarded the dying declaration, so they were given the benefit of doubt and acquittal was awarded. Paragraph 40 of the judgment. 2024, 17 SCC 735. 17 SCC 735. Paragraph 40. It can thus be seen that this court has clearly held that dying declaration can be the sole basis of the conviction if it inspires the full confidence of the court. The court is required to satisfy itself that the disease was in a fit state of mind at the time of making the statement and that it was not a result of tutoring, prompting, or imagination. It has been held that where the court is satisfied about the dying declaration being true and voluntary, it can base its conviction without any further corroboration. It has further held that there cannot be an absolute rule of law that a dying declaration cannot form the sole basis of conviction unless it is corroborated. It has been held that the rule require corroboration is merely a rule of prudence. The court has observed that if after careful scrutiny, the court is satisfied that it is true and free from any effort to induce the disease to make a false statement, and if it is coherent and consistent, there shall be no legal impediment to make it the basis of conviction, even if there is no corroboration. And regarding if there is any contradiction between the ocular evidence and the medical evidence, which one shall prevail? para 23. 2025 SCC online SC 2190. Paragraph 23. It is well settled that if there is a conflict in the ocular testimony and the medical testimony evidence, it is the ocular evidence which will prevail unless found to be totally unreliable. It is in this regard, reference may be made to the following decisions wherein the above principle was reiterated. 23.1 in the judgment so and so. So far as the question of inconsistency between the medical evidence and the ocular evidence is concerned, the law is well settled that unless the oral evidence available is totally irreconcilable with the medical evidence, the oral evidence would have primacy. In the event of contradictions between the medical and ocular evidence, the ocular testimony of the witness will have greater evidentiary value vis-a-vis medical evidence. And when medical evidence makes the oral testimony improper, the same becomes a relevant factor in the process of evaluation of such evidence. It is only when the contradiction between the two is so extreme that the medical evidence completely rules out all possibilities of the ocular evidence being true at all, that the ocular evidence is liable to be disbelieved. Second, in the judgment of State of UP versus Harichan, it was held that in any event, unless the oral evidence is totally irreconcilable with the medical evidence, it has primacy. Next again, Lordship, in the judgment of so and so, ocular evidence is considered the best evidence unless there is reasons to doubt it. 23.4, in the aforesaid decisions, the court has consistently accorded greater weight on ocular testimony than to the opinion of medical experts, and the same principle governs the case before us. So this is very important. Weight on the ocular testimony more greater than the opinion of medical experts. And the same principle governs the case before us. It's similar in this case also. And here, last one judgment. What is the opinion of the medical practitioner? Paragraph 15. The opinion given by a medical witness need not be the last word on the subject. Such an opinion shall be tested by the court. If the opinion is behead of logic or objectivity, the court is not obligated to go with that opinion. Paragraph 15. After all, opinion is what is formed in the mind of the person regarding the fact situation. If one doctor forms one opinion and another doctor forms a different opinion on the same facts, it is open to the judge to adopt the view which is more objective or probable. Next line, similarly, if the opinion given by one doctor is not consistent with the probability, with probability, the court has no liability to go with the opinion merely because it is said by a doctor. Of course, due weight must be given to opinions given by persons who are expert in a particular subject. But basically, the court should not blindly follow the opinion of the medical practitioner. Now, if I take your lordship to the part of the judgment,
That's at 120.
starts at 120 from the relevant part, page number 149. There were two aspects why the dying declaration was discarded. Page number 149, the last paragraph, the judgment. Number 149. In the instant case, two major points about the truthfulness of the dying declaration were which immediately cropped up are number A, what was the source of recognition of the accused person by Moinul, by which Moinul recognized them? This was a question that came up to the learned trial court judge. The prosecution is absolutely silent about the presence of some light with the help of the accused person, which the accused person were recognized by Moinul to be named before the prosecution witness. Now here the court has come to the finding that there was no light, but admittedly it was a call from him. That is why the question came up, why was the call and why did he go outside when the call was there? So he went, obviously he knew that person. So irrespective of the light, because the bike, when he came, there was light, there was a function going on, he went with him and later on this incident happened. So the question of light does not come here. Because he knew that person got a call, he went with him. He knew that person. Number B, if Moinul could recognize 9 accused persons that he named, why he failed to recognize the other 4 accused persons who were subsequently brought after recording the statements under 161 CRPC of Hazrat Ali and Abura, whose statements were recorded after 2 months of the occurrence. This delay has not been explained by it. So later on, some more accused persons were there and these persons had lived. But this is totally not linked because these stated so and so, these.
Deceased.
Yes.
Minor is the deceased.
Minor is a disease. So the question has come up, he has taken name of 5 persons, for example, why has he not taken the name of the other? It is he who has stated the names, the dying declared. Later on in 164, some other persons took name of some other persons, but those were not in evidence. 164 was not exhibited, only one person, 164 was exhibited. So this was one part why the dying declaration was discarded and the medical. Medical is at page number 153.
No, what is the logic behind it?
That is what? What is the logic behind
If
it? Is typical of
he
me also.
recognized 9%, why he failed to recognize the others? Who were subsequently brought after recording statements of 164. So how long was he alive?
On the way,
On the way to the hospital, he
on the
died.
way. But these 2 persons in their 164, they had stated that he had named some other persons, some new names, which were not taken up by the disease. In the 164, this 2 person has taken that names. Some other names. So the trial court came to the finding that the accused could have taken all the names
All
in
the
this
names.
first instance itself. Why did he take name of some and he did not take the name of some which were stated by these 2 persons? But I am not on that. Let me stick with the names taken by the accused. Why he did not take names of others is not the question here. No. He is in the brink of his death. He has taken names of 9 accused.
He was in that condition.
He was
in that state of.
He was in that state.
Where was the question of him being meticulously naming 1, 2, 3, 4, 5?
He might forget names of some. It is natural and has to be there at that point of time and the brink of his death. So that is one aspect, and page number 153, that is the medical aspect. And one more thing regarding the light. The light also has been stated. Because how could he see? That is question has also come up because there was no presence of light. That is also stated. He knew that person. He knew all of them. Even irrespective, fine, not all of them, but he knew the person who has called him and with whom he went. Everybody saw him going with him. If not, fine, the call was not made. But the other persons who later on went outside after the event, right? Everybody knew that Patalam has called him and he went and they saw them going in his bike. So he knew the person with whom he is going. That does not require any light to recognize the person with whom you are going on a bike. So that is one portion, and the medical 153. Page 153, second paragraph. Another factor that goes against the prosecution is that the conduct of the accused persons, which under the fact and circumstances of the case cannot be treated as natural. This is a question, that is a question is whether after committing a crime like murder, accused persons will come towards a place where there were hundreds of people present instead of running away towards the direction from where there were no human beings, or took the flight through paddy field where there was no chance to see them and where they could easily conceal themselves. Thus, the prosecution has projected a story that all the accused persons strangely came armed with deadly weapon towards northern side where the jatra was going on, and they were identified by the witnesses. It is naturally against the human conduct and it cannot be readily believed. So the trial court has come to the assumption that after committing a crime, they would run away.
Normally one runs.
Normally one.
They came.
But here they were coming to a side, but they didn't know who was coming from the other side. So they came from the other side and they saw this person, the four witnesses were seen. And that was confirmed in their cross, their presence, all crossed them. So in the cross also that was confirmed by the eyewitnesses, the ones who crossed them. In the cross examination, the defense itself confirmed their presence. So the court to come up with its own assumption, not based on any evidence, that why would they come to that direction? But that was given in the chief, and in the cross also that was confirmed. Their presence, that they had crossed them by the defense itself. Another aspect, another important factor, page number 153, the second last paragraph, the one which the lordship's query had come out. Another important factor is that the deceased minor, one of the accused, is the murder case, in the murder case of the father of Khaja Alam. So he is one of the accused in the murder case of Khaja Alam's father. And if so, it is so. Page number 153, last
paragraph.
Last paragraph. So another important factor taken into consideration by the trial, that a deceased minor, one of the accused in the murder case of the father of Khaja Alam. And if it is so, how can court believe that the killer of one's father will have such sweet relation between them that one of them will leave from enjoying Jatra after receive a phone call, and that too at the dead of end, with a person whose father was alleged to have been murdered by the person who was called out. Even it,
Father of whose father?
the one Khaja Alam's father was murdered. There is a trial going on, and in that trial, this person, Moinul Islam, was an accused.
What has happened to that trial?
That time it was going.
I'm not aware of it.
That time it was going.
By now it was a.
I don't know, my lord, but that time it was going. Probably, my lord, we already know that he was the main accused. He was the main accused.
Ajalam says that he has ended in acquittal. Ajalam in page 65 said both the cases were ended in acquittal.
There's a cross case.
Page 65.
There's a cross case.
He says both cases ended in acquittal. The cross and the other court have ended in acquittal. In the said case, myself are witness and they are accused. Then he says that there is a cross case. Both the cases ended with acquittal.
But at the time, when trial of this case was going on, that was trial of that case was going.
But he doesn't find that is the Khaja.
Minor.
He is giving evidence in trial, this trial,
Minor.
that both cases have ended in acquittal.
But your lordship kindly, I'll come to that one because there is another evidence, my lord, that is at the time of my lord, death, my lord, this my lord is person.
At the time of death of Moinul, murder case of
That's going on.
that was going.
Going.
By the time he gives evidence,
Immediately, he no more than five, my lord.
I'm more than acquittal.
More than it.
Promoted. There's a word called promoted deploring.
Not only that, grandfather was also killed by the same family.
The enmity rises.
I say the hereditary enemy, man. My grandfather was killed, my father was killed.
So the judgment part, as I was referring to your lordship.
Page 149. And 153.
Page 149, then 150 also, lordship. 150,
What is there in 150?
150, the medical. The court relies on the medical evidence. Page 150, second last page. It further surfaces from the evidence of the doctor that there was profuse bleeding in such type of injuries. And when a person sustains such type of injury, he immediately comes under neurological shock, and due to exposure of brain matter, a person immediately becomes unconscious with shock. The positive statement of the doctor was that due to exposure of brain matter, a person immediately becomes unconscious with shock. So it is hard to believe that the disease before made dying declaration was in a state of mind position to give such dying declaration. So the prosecution evidence in this regard is not believable under the facts and circumstances of the case. So he relies on the medical. Admittedly, he relies on the medical, and the medical examiner says, but that thing was not corroborated by the ocular evidence. They have stated they have seen injury marks. Inquest also, it states injury marks are there, but the brain coming out, true, they are not trained individuals. They will not be able to say properly, but the brain coming out can be, I think, said by a layman that the brain was visible, it had come out. So later on, due to the tendency of time, the injury, it has come out. The brain has come out, and it can happen during the course of time. So now only on the basis that a doctor said that if such injury is there, immediately he'll become unconscious, then the whole dying declaration can be doubted. On that basis, mainly on that basis, the acquittal was. I have given your lordship that the evidence of the medical practitioner is not binding. The court has to see overall circumstances. And as I have given one judgment page, paragraph 15, the opinion given by the medical evidence need not be the last word on the subject. Such a opinion shall be tested by the court. If the opinion is beneath of logic or objectivity, the court is not obligated to go by that opinion. After all, opinion is what is formed on the mind of the person regarding a fact situation. Ultimately, it is the opinion of the doctor. Now, whether at that point of time he was unconscious or not unconscious cannot be said at this point of time, at a later after 12 hours when the postmortem is conducted. Because the ocular evidence specifically states, and that ocular evidence is consistent. The witnesses have stated in their evidence, which was not demolished during the cross-examination, nor it was brought before the IO. That statement is consistent that their names were taken by the person before his death. And Lordship already knows nobody will lie before going to meet their neighbors. So that is said. Normally, a person in the brink of his death will never lie. But now the question is only regarding this medical.
Any authority on that?
I have given the authority, that is when there is contradiction between the medical and the ocular.
No. The person on the brink of death will not lie. Any authority on that?
That is what is said and believed.
There's a belief, of course. Brink of death, the brink of drowning.
But
It appears, it seems that the person remembers everything.
especially for
Like a flash, right from the childhood till adulthood. What has happened?
But-
Person remembers.
and they don't normally lie. So that is my case. On that basis, the acquittal was given. And I challenge that these are the aspects it was not taken into consideration. The consistent evidence of the dying declaration that was witnessed by PW 1, 2, 3, and 6. Those are consistent throughout. It was never broken in evidence.
So how many names were taken by him? The time to
In the dying declaration, total 1, 2, 3, 4, 5, 6, 7, 8, 9. Those 9 names in which the FIR has given. The same way
Right,
FIR was given, those 9 names.
So why have you singled out the accused number 1 and leaving 8 behind?
Lordship, because the
The
others,
multiple injuries, everyone will have a role, probably.
Lordship, there are multiple.
No, why have you singled only 1? There must be some reason behind.
I believe he is the main one who called and with whom he went. So that is why the instruction was given.
Oh, that way.
was first done, I just repeated the two, like.
All right, we'll come back. 5 minutes. You're done. Otherwise,
Yes, I'll reply if required. Please, the Lordship, as your Lordship said, there is a legal maxim. Nemo moritus desamortu mintu. That is what says. Right? Literally translated, it means a man will not meet his maker with a lie in his mouth. That is a legal maxim.
okay.
Okay, I think he.
But question is this, my lord, whether he is a condition to, my lord, speak, my lord. That is the main case here, my lord. And for going to that, my lord, you have to start from the FIR, my lord. Here, what happened, my lord? There is a enmity between the family that is apparent. Because my father was killed, there is the person who died in this case, my lord, he is the prime accused of that case. And my grandfather was also killed by the same family, his uncle family. So the relation between the two family is, my lord, not cordial, and from very beginning of last several 2-3 decades now. Now, your lordship, kindly see the ZD&T, my lord. Who has made the ZD&T? A ZD&T, my lord. On the basis of the ZD&T, my lord, police, my lord, moved. And FIR was lost after 12 hours, my lord. And I'll come that, my lord. His suspicion arise, my lord, from there, made out a case from very beginning, my lord. Your lordship, kindly see the ZD&T at page 171, my lord. 171. Oh, sorry, 172. Yes. 172. Now, Mr. Wan Mubarak Hussain, a member of VDP, the Village Defense Party, he is the most important and independent witness of the village work Borkolabari. Translation inform about on that murder has been committed in a village so and so. He is in the night patrolling to proceed with the place of occurrence. OCSI so and so. So that was he was in night patrolling because he is a VDP party member. So he got the information and immediately he informed the police. So that was, my lord, at 1:40. So received this information. The police started their inquiry, my lord, after making the ZD. Now, your lordship, kindly see. This FI was lodged when? After 12 hours. Because in GD&T is simply stated, my lord, that a murder took place. Incident took place. He was in VDP party. So he came to know, he informed us. After 12 hours, FIR was lost. What they stated? Why they are waiting for 12 hours, my lord? Because he died immediately, my lord. They should have within 1 hour, 2 hours, they should have, my lord, lost the FIR. But FIR was not lost. FIR was lost after 12 years. So that they make out a case, my lord. Because this VDP man, my lord, who lost this, my lord, is AD&T, he was not examined. At first instance, he know everything, my lord, but he was not examined, my lord. So, your lordship now come to the, my lord, FIR. FIR page, my lord. Page 1, my lord. So date of occurrence, my 19/2/2012. That was the month of February, my lord. On 19th, at time, my lord, at 11, occurrence time, my lord, 11:59 p.m. They informed the matter before the police, my lord. Next day, 12 p.m. Page number 11, my lord, your lordship can list. By naming 9 accused persons. I have the honor to state that at about 11:58 p.m. on 19th on 2012, when my elder brother Moinul Islam was watching Jatta party, that is drama, my lord, held in Nandini Kamari village, aforementioned number one accused person called him out to discuss something in a planned way, and furtherance of the conspiracy while they were going towards the Bakolibari by bike belonging to Moinul Haq. Above mentioned accused person equipped with weapon lowered Moinul Islam down from the bike and caused grievous injury to him by repeatedly assaulting him with a sharp weapon. Having learned about the incident, we rushed toward the place of occurrence and got to know that name of the address of those accused person from him, Moinul Islam, in his injured condition. So we immediately took the injured person to the Morigaon Civil Hospital. He succumbed to the injury on the way. So your lordship kindly see, this is the FIR laws, my lord. After 12 hours naming the my lord, your lordship kindly see the content. I am not a good fan to him, my lord. Give a missed call and give a call, he'll come out from the Jatra. He enjoying a my lord drama. So I give a call and he come out. Come out with whom? The killer of the my lord? My father. So is it humanly possible, my lord? Your lordship, I will come to the evidence, my lord. In one evidence, PWT says that I have given a missed call. And getting my missed call, he came out. So if it is so, my lord, they knows, my lord, that I have given a call. Then, my lord, why they have not, my lord, lost the FIR immediately? And very interestingly, my lord, for the IO to justify this, my lord, immediately he should have, my lord, seized the mobile. He should have, my lord, call record. Why that was not done? I have not done anything regarding, my lord, call record. It will come to the light, my lord. Because it is very easy nowadays, my lord, to detect the call record. That was not done, my lord. But after 12 hours, naming these 9 persons, who are they, my lord? They are the witness of that murder case, my lord. So some of them, my lord, not all, some of them, my lord. And very interestingly, my lord, in this case, my lord, while charge sheet was submitted, the lordship kindly see the sequence, my lord.
One thing, Mr. Partha,
My lord,
this date 7, this is the FIR. Date-
my lord.
Why the date is different?
So there are different FIRs.
So my lord, my father's other FIR also here, my lord.
They were also exhibited.
They are exhibited, my
He is
lord.
going-
These are
This
not
is
the
a
FIR.
different, this is a different FIR.
Different FIR.
This FIR is page number 11. We are concerned with this case. This is page
We,
number.
here in this case, only the page number 11 is the FIR, it's concerned FIR. My lord. Others are, my lord, other murders case.
And the
All the three are, my
format
lord.
is page number 1. That is the format of in connection with this. Yes. Page number 1 FIR format and the contents is page number 11.
Okay.
So your lordship kindly see, my lord, here in this case, charge sheet was submitted after making an inquiry. And there are 14 numbers of witnesses were cited in the charge sheet, my lord. 14 numbers, my lord. Your lordship kindly see the charge sheet, my lord. Charge sheet, page 8, my lord. (178). Your lordship kindly straightway goes to page 80. Page 80, my lord. Name and address of the witnesses. What point each of the call to quote the 16 witnesses were cited, my lord. 2 are official, my lord. So 14 are there, my lord. Out of those, my lord, only 8 were examined before the court, my lord. Others were not examined. That's why, my lord, defense, my lord, they have examined as a PDW, my lord. PDW 1, 2, 3, 4, and 5, my lord. 5 is the accused here, my lord. There are 4 witnesses who were cited in the charge sheet as a witness for the witness of the prosecution, my lord. They were not examined as a, and they know, because they know that everything, my lord, the right, they did not support the prosecution case, probably apprehending that, my lord, that is not denied. So they will examine as a deed of human. I'll come to that later on, my lord. So these are the sequence, my lord. Your lordship kindly see. PW1, PW2, and PW3. Who they are, my lord? They are all relative. And PW1 is the brother of the my lord. This is my lord. And he says that I recognize them from torchlight. But is it possible to recognize 9 persons from torchlight? But torchlight was not been seized by the IO. It's a month of February 2020. It's a dark night and month of February in Morigaon district, my lord. My lord, there will be my lord foggy night. In foggy night, 12 o'clock, occurrence took place. Can it be possible to identify all these persons, even in the person who died? How can I recognize, my lord? There is no light. Admittedly, there is no light in the place of occurrence. So, even my lord, they say that I recognize them from my lord torchlight, but that torchlight was not seized. I don't know why that was not seized, my lord. And not only that, my lord, your lordship kindly see what they says. Your lordship kindly see the sketch map, my lord. I am not going to read the evidence because you have already read the evidence, but I will read the evidence of DW5.
Mr. Manta, before that, how many were accused?
They are accused, there are 9 accused, my lord.
In the charge sheet.
In charge sheet, there are 13. Why, my lord, there are 13, my lord?
But
In,
there are
after 2 months, my lord,
5 of them are absconded.
my lord,
5 have absconded. Page 178.
170.
178, it says absconded.
Five were responded. But later on, everybody appeared, so the trial went against 13 of them.
Right sheet.
Ordinarily in the FIR, 13 was, 9 was there. So after 1 and 2.5 months, my lord, once on the basis of the another person 164 statement, my lord, and they were, my lord, raised to my lord, implicated at another 4 more.
Total how much?
My lord.
Total 13.
Total 13, my lord. 9 plus 4, 13.
But the
Now your lordship kindly see 176.
prosecution witnesses, there were 16,
16,
but only 8 examined.
16, 2 are official, yes. 2 are official. That is IO and medical, my lord. 14 out of 14, only, my lord, 7 were examined. 7 were examined. And 4 were examined by the defense, my lord. As a TW, my lord. Now, my lord, your lordship kindly see the sequence, my lord. That's sketch map of the place of occurrence. Page 176. 176, my lord.
Yes.
That is, my lord, place of occurrence, that is F, my lord. Sorry, place of occurrence is A. Mark as A, my lord. And F is the, my lord, place of occurrence. Oh, sorry, my lord, F the Zatta party, where, my lord?
Jata party.
Zatta party. So, Zatta party, that is, my lord, northern side. And, my lord, southern side, place of occurrence. So, it is a normal human, my lord, behavior. If anybody committed a crime, he will definitely, my lord, go to the, my lord, place where there is no light. Where there is, my lord, pedophilia is there, they will hide them. But here, my lord, all the evidence says, my lord, they are coming from south to north, where, my lord, Jatta party is going on. So that was the one of the finding of the land trial court also. I have seen, my lord. That's why I'm submitting, my lord. That's a normal human, my lord. Your lordship kindly see if I committed a crime. Definitely I'll go to the, my lord, public place and go to the light, my lord. I'll go to that place, my lord.
But what about the weapons carried by them?
My lord.
Weapons.
Not seize. Not seize, my lord. I'll come. My lord, everything. The not seize, my lord. So my submission before your lordship kindly see the learned trial court. Considering all these aspects, my lord, came to a definite view, my lord. So that view is possible, my lord. That possible view, my lord, in a appeal against acquittal, very difficult to, my lord, interfere with, my lord. There is a judgment on, my lord. Because if it is completely, my lord, disregard the situation, disregard the evidence, then, my lord, the appellate court has a power to interfere with, my lord. But here in this situation, your lordship kindly see. Now your lordship kindly see the PW5, my lord. DW5, sorry. DW5, my lord. Because DW has the same value as BW, my lord. Your lordship kindly see page 65, my lord. Page 65, my lord. Page 65, my lord. Your lordship, page 65. Yes, ma'am. Khaja Alam, against whom this appeal has been filed, my lord. I am the accused in this case. I know Moinul Islam, who was the accused in the murder case of my father, Muhiduddin. Moinul is now died. There are other 11 accused along with Moinul Islam, namely Ainuddin, Jamaluddin, Atabuddin, Omar Farooq, Nur Nuhar, Sultan Mahmud, Abdul Ali, Isam Ali, and Razauddin. They are from same family. In the said case, myself along with Abdul Jalil, Safaruddin, Fakaruddin, Sahiduddin, Aizul Haq, and Ahmed all are witness and they are accused in this case. So your lordship kindly see very important, my lord. Who are the, my lord, accused in this case? Those who are witness in my father's murder's case. The said case myself along with the Abdul Jalil, Sharifuddin, Fakaruddin, Sahabuddin, Azizul Haq, Ahmed Ali are witness and they are the accused in this case, that means present case. The aforesaid or persons are related to me and are some same family. One Ramzan of the family of the Moinuddin filed a case against us on the death of murder of my father. Accused myself and all other accused persons except Saidul, Hakiul, Nurul Amin in the case brother of late Moinul are the witnesses. Both in the said case were ended with a acquittal. Moinul died about 4 years ago. I have already initiated that died due to accident. But later I have heard that he was murdered. At the time of death of Moinul, the murder case related to the death of my father was going on. About 18-19 years ago, prior to the murder of my father, my grandfather Lukman was murdered by Hazrat Ali and Idris Ali. Idris Ali is the PW2. PW2 who? He is the, my lord, accused of my grandfather's, my lord, murder case. They are related to Moinul and Omar Farooq, who are accused in the murder case of my father. Since the murder of my grandfather and father have not maintained, since the murder of my grandfather and father, we have not maintained good relation with them and we tried to avoid them. So that was the evidence, my lord. So I have no good relation since my grandfather that died. So that person give a call to my lord, the deceased, and he will come out from the Jatna party. Is it a believable story, my lord? It is humanly not possible, my lord. Even I call my lord, then he will not come, my lord. because he'll be have to fear that to kill me because my father. So enmity is there, my lord. So even my lord, if your lordship go by the PW3's statement, in that statement he said that I have given a missed call, not even a call, a missed call. So your lordship kindly see that, my lord, and I'll read the, my lord, page 66, my lord. It is not a fact that I give missed call to Mainul Haq in mobile and he came out from the Jatra party at Kamli. I took him to the motorcycle, then murdered him. My house is situated about 8 kilometers east from the community. There was two routes near the place of Jatra. They are running to the north, south, and another is running was the western side. From Bokalibari, Sariali, my house is situated at the eastern side. Bokalibari, Sariali is about 1.5 kilometers away from the Jatra party. From Bokalibari, Sariali, my house is situated about 1.5 kilometers away. Jatra party was held on the north side of the road, on the eastern side of the paddy field. At that time, it was a season of mustard cultivation. My house is at about 1.5 kilometers away. If go through the paddy field, I do not came to see the incident of Moinul. Exhibit is the certified copy of the FIR filed by the Abdul Jalil against the Ainuddin exhibit. Moinul Haq and another exhibit one is the charge sheet in the same case. But the exhibit B is the certified copy of the FIR filed by Ramzan Ali against the Jaliluddin Jalil Munshi in 16 other. Exhibit is the charge sheet and Zainul are the relative of the Ainuddin and Zainul are relative of Idris. This is Malab PW2. Atabuddin also an accused in the murder case of my father. Atabuddin is the cousin of the Idris Ali. Idris Ali is the witness in the case and accused is the accused murder case of the Lukman Ali. Mother of Jalilur Rahman has the witness in the case filed by Rahim Ali. Allegation made against us by the company is totally false. I have not remembered the case number of my father's murder case. Moinul died about 4 years later. 4 years later from the death of my father. Continue. It is not a fact that a conspiracy with the other prosecution I call Moinul by getting missed call and kill him. It is not a fact that there is no any enmity from the previous guard. Moinul and other. It is not a fact that the accused persons of my father murder case has not related to each other. It is not a fact that I depose both. So, my lord, this EW has also, my lord, same value as my lord. Your lordship kindly see, he has clearly stated that we have no good relation with them. And so, my lord, where is the possibility to give my lord missed call?
Which was Manta. Apart from that, what does he know about this incident? Is it on his page 65? That he said, I have heard it was a murder. That
My
was
lord.
DW,
My lord,
DW5.
my lord.
What does he say about that allegation made against him? Apart from saying that they are,
No, these are false. He stated in the ship. Your lordship kindly is totally false, my lord. Your lordship kindly see.
no, come to page 65,
My lord.
4 lines from the bottom. Third line from the bottom.
I heard initially that he died due to the accident, but later I have heard that it was a murder. At the time of death of my Moinul, the murder case of related to the death of my father was going on. About 18, 19 years prior to the murder of my father, my grandfather Lukman was murdered by Hazrat Ali and Idris Ali. They are related to Moinul and Umar Farooq, who were accused in the murder case of the father. Since the murder of my grandfather and the father, we have not maintained good relation with them, and they tried to avoid them. It is not a fact that I have missed the missed call, maintained this Moinul in his mobile, and he came from out of Jata party, and I took him to the motorcycle and then murdered him. So he also, in chief, my lord, he denied everything, my lord. So, your lordship, my lord, what I want to prove, my lord, because it is clear that, my lord, we have no relation with them, my good relation. So, why, my lord, giving a missed call?
No, that much is okay. No good relation. There's already a murder case going on. They are the accused. Those are there. But regarding the death of this Moinuddin, what does he know? He just says, I have heard about
Yes.
he was
They-
murdered. Initially he says accident, then there are.
Not initially he know that accident, and later on he, my lord, they came murder, my lord.
And where was he at the time of this incident, according to you?
So that was not
No indication.
no indication. Even then, that point, there is no cause also, my lord. So your lordship now, my lord, see the DW 1, 2, and 3, my lord. They also, my lord, says the same thing, my lord. They are although cited by the prosecution, my lord, but they were not examined. So your lordship kindly see, my lord, DW 1, 2, and 3, my lord. Here it is. Page 57, my lord.
Page 57.
Page 57, my lord. DW 1. About 3 years ago, page 57, my lord. About 3 years ago, I went to enjoy the Jatra about 10:30 to 11 p.m. at Nandini Kumari. On my way to the Nandini Kumari, I have found one bike was lying by the side of the road, and there was a person under the bike. The distance from the place of the place to place where the Jatra was performing at about 100 meters. I went there and told the Anand Mandal that one bike was met with an accident and was lying there. So soon as the news of accident spread, and then Jatra part was stopped and some persons came to the place of accident, and I, along with the Anand Mandal, also came to along with them. After our arrival, I identified the person was as Moinul. I did not know whether he dead or alive, and nobody asked any question to Moinul. Thereafter, Moinul was taken from the place. I do not know who has took away the Moinul the time of when the informed Anand Mandal song were running in the loudspeaker. There were so many small shops near the place. Cross. My house is situated about 350 meters away from the place of where the bike was lying. When I arrived there, Jatra was started, but I do not know at the time at what time it was started. I did not inform police about the said incident. Police examined me after 3-4 months after the occurrence. It is not a fact that I deposed falsely and Munil was lying on the road under the bike. Accused Jalil Munshi was also with the police also with the police when police came to our village. I did not disclose about the incident to anybody except Ananda Mondal. It is not a fact that at that time I was enjoying Jatra and went to the place along with the person that I has not seen Monjul on the road. It is not a fact that I deposed falsely in favor of the accused and ordered by accused Jalil Mondal. That is, my lord. Your lordship kindly see he was also cross-examined, my lord. Did not so your lordship kindly see he also stated what he seen, my lord. TW2, my lord. About 3 years ago, I was a Jatra performance was Nandini Kamari village. I was enjoying the Jatra about 11:30 to 11:45. Nilamani Biswas informed me that one bike also along with the person was lying by the side of the road. When when the news play was stopped and many persons, including the Nimai Biswas, went to the place where the bike was and persons were lying. I have seen the persons and bike from the focus of this light, which was paid by a person. The place where the bike was lying about 150 to 200 meters away from the Jatra place. I did not recognize the person. I do not know whether Monil was dead or alive. He was in the pool of blood. My house is situated less than 1 kilometer distance from the place of where my bike was lying. I have not seen occurrence at that time. I was enjoying Jatra when the play was going on, and I have heard that one person was lying with a bike on the side of the road. As the play was stopped, and I proceed toward the place. When I arrived there, so many persons arrived the place of occurrence. Police examined me, and there about 3 months, 3 months back from the occurrence, police came to the place of occurrence while I was there, but I did not say anything to the police. While police visited my house, then 2-3 accused persons accompanied the police. Out of them, I came to recognize Saidul only. It is not a fact that I deposed today, told by the accused person. Police arrived when I was in the place of occurrence. It is not a fact that I deposed falsely. Now, my lord, your lordship kindly see PTW 3, my lord.
No, one thing, he says to the chief, bike was lying about so and so.
My lord,
I did not recognize the person.
my lord.
But again, he says, I do not know whether Mainul was dead or alive, as he was in a pool of blood. Something wrong.
No, my lord.
He does not recognize.
Initially, they are not recognized. Later on, he came to know, my lord. That's why it is that is, my lord, after so many years, my lord, so many years, he deposed, my lord. He says, my lord, that initially, I don't know what he was lying in the, my lord, under the bike. But later on, I came to know, my lord. So now, my lord, your lordship kindly see TW 3. So TW 3 also stated, my lord, that more or less, I think, my lord, same, my lord.
Ajit Mandal.
Proceed, Mandal. Now, your lordship kindly see the inquest.
Anybody has taken his name? Ajit Mandal. And
No, Ajit Mandal was a cited witness of the, my lord.
DW1 said that he informed DW2.
My lord.
DW2 also said that he was informed by DW1.
They are enjoying the Jatra, my lord.
And DW3, how does he come in?
DW3, my lord. About 3 years ago, Jatra was going on at I went to enjoy the Jatra and I have seen the bike was lying on the side of the road without start of the engine, and one person was lying below the road. The person was seemed to be lying there without any voice. After arrival of the place of Jatra, I informed the people that Jatra about lying on the motorcycle and the person. Then Jatra was stopped, and I, along with the persons, some person came to that place where the bike was lying. While we are coming to the place, we have not seen any other person on the road. We are the first arrived at the place of occurrence. I came to know that the person who was Moinul, I came to know. I do not know whether the person was dead or alive. Police examine me. Further examination is reserved. So, my lord, he himself, my lord, went there. Nobody called him, my lord. He have seen, and he is the person who informed the, my lord, other person in the Jatra party, my lord. That first person, my lord, did not find out anything, my lord. From that, I cannot remember that the time of the occurrence, my house is situated 100 meters away from the province. I did not see the person for the day. I came about 110, 20, Jatra party. Jatra panel is situated about 350 miles away from the meter away from the place of occurrence. Jatra panel generally started at 11 to 11:30 p.m. And Nimai Vishwas was also accompanying me while I came to the Jatra panel. I was on the road and the next person was staying. I did not know to inform the police, but I informed the incident at the Jatra panel. The persons gathered there. I was not present at the place of occurrence. While police arrived, police examined me at 3:30, 3.5 month. I know the accused Jaliluddin Munshi, and I went with the police. It is not a fact that I deposed positive today. When I informed about the incident, the Jatra panel about 20 to 50% share the place of occurrence. It is not a fact that I did not see the incident. It was the in favor of the actual person. So PW4 also, my lord.
How many of them are there?
My lord.
Depends.
My lord.
Five.
5, my lord. There are 5 people. 5 is the, my lord, accused. So, my lord, considering these all aspects, my lord, your lordship, my lord, the learned trial court come to a definite view, my lord, which was possible view, my lord, and that's why, my lord, that is very. Now I'll come to that, my lord. Now regarding by the defense witness, there is the same value, my lord, as PW, my lord. I'll place one again. That is 2002 to SCC. Wait. Para 19, my lord. Para 19, middle portion, my lord. Defense witness are entitled to equal treatment and equal aspect as that of the prosecution. That was the middle portion of the para 9, my lord. Now, my lord, your lordship, my lord, I will. Where is the PW9, my PW9 is the IO, my
Okay.
PW9. Here in this case, my lord, who carried the dead body? Dead body was, my lord, carried by the dead pilot PW1, 2, and 3. Inquest report was not done in, my lord, inquest was not done in the place of occurrence because there is no light. That was body was carried by them, my lord. And there is no light. It was, my lord, inquest was done in the place in front of the police station, my lord. Not in the place of occurrence.
So that is seen from the IOS.
IOs, my lord. And very interestingly, my lord, your lordship, in the first part of the IO, already my learned pen has read.
IOS at page.
Yeah, IO is page 53, my lord. No, my lord, PW1, page 55, your lordship kindly see. Page 55, PW1. Moizuddin did not state before me that Raza Khan called Moinul over telephone prior to the occurrence. Moinul came out from the pandal and went Kaza Khan. So, my lord, PW1, they improved the case, my lord. They have not stated before the police. Their version, my lord, in the before the court, my lord, really improved, my lord. They have not said that, my lord, before the IO at the very point of time. That he was called, given a call given by my lord, the accused, and he was come out. Again, also PW2 also, my lord. Idris Ali did not state before me that Zoinal also accused him to enjoy Jatra. He did not stated before me that Kajol Alam called Moinul on 15. He also did not state before me that Moinul went out from the place of Jatra on a bike along with Kajol Alam. So that is PW3 also, 2 also not stated before IO, my lord. Then, my lord, PW3. That PW3 is Isadul Haq stated before me that we went out at 11:59 p.m. to enjoy the Jatra. Witness stated before me that Moinul informed him that he received a missed call from Kajol Alam and went out to meet with Kajol Alam. Witness did not state before me that Kajol Alam also going with a Moinul on the motorcycle by sitting in pillion rider. So that was not been stated before the IO, my lord. So, my lord, PW1, 2, 3, they improved the case before the, but that is why, my lord, learned trial court considering all the evidence, came to a definite finding. And now this, when the trial court came to a definite finding, and then, my lord, it is, my lord, very difficult, my lord. It's very difficult to, my lord, interpret with the judgment, my lord. On that account, my lord, I placed one judgment. There are three judgments, my lord. One is very leading judgment. 2007, 4 SCC 415. These are the, I take one by one, my lord. It is 2007, 4 SCC. Well, paragraph 42, my lord. From the above discussion, in our considered view, the following general principles regarding the power of the appellate court while dealing with a appeal against the order of acquittal emerge, my lord. And page para 42 and 44, my lord.
It is regarding.
Regarding, my lord, when two views possible, my lord, when the views, my lord, the possible view is taken by the trial court. Your lordship, page 42, subpara 4, my lord. So your lordship can listen. An appellate court, however, must bear in the mind that a case of acquittal, there is a double presumption in favor of the accused. Firstly, the prostitution of presumption of innocence is available to him under the fundamental principle of criminal jurisprudence, and very persons shall presume to be innocent unless they prove guilty by competent court of law. Secondly, the accused having secured his acquittal, the presumption of the innocence of his father strengthened by the trial court. If two reasonable conclusions are possible on the basis of the evidence on record, the appellant should not disturb the finding of the acquittal recorded by the Lana trial court. Paragraph 44, my lord. In our view, in the light of the above circumstance, the trial court felt it that the accused could get benefit of doubt. His said view cannot be held to be illegal, improper, or contrary to the law. Hence, even though we are of the opinion that an appeal against the acquittal power of the appellate court are wide, that the trial court and it can view respective and our the even evidence throughout the record by the parties, it can came to own conclusion of fact as well as law. In the present case, the view taken by the trial court for acquitting the accused was possible on the basis of the evidence. Therefore, at the most, it can be said that other view was equally possible. But it is well established that if two views are possible on the basis of the evidence on record, one favorable to the accused has been taken by the trial court. It ought not to be disturbed by the appellate court. In this case, a possible view of the evidence of prosecution had been taken by the trial court, which ought to not have been disturbed by the appellate court. With decision of the appellate court, that's so it's said and changed. So in that case, my lord, acquittal was by the trial court. High court reserved verdict, and then honorable surface court says, my lord, So only crux, my lord, to look into, my lord, the view which was expressed by the trial court, whether it is based on the evidence on record, is a possible view or not. If it is a possible view, my lord, it cannot be, my lord, turn around, my lord. So in that line, my lord, there is that still, my lord, this judgment, although it is 2007, that is same view has been respected in respect of 2012 10 SCC and 2021 3 SCC, my lord, and 2009. This four judgment I will come this. I'll take only 10 minutes.
So both families have enmity.
From the game for that.
Earlier case also the acquitted. This case also acquitted. Nobody is convicted.
I don't know what happened to the game for that.
Everyone is getting acquitted.
Direct
Promoted. Not.
He was no, he heard. He heard. Then he made it. The way that- It is off the car because the person.
Yes, very moment, yes. On the same day night.
Karate power. Yes. But then now. Statement of the higher. It is either live at the place of operation. With everyone.
And the person who lost the my lord, Syrian,
Not sure. I don't know.
The page 53. I arrived at the place of occurrence at 2:30. He showed me Mujahidul Islam, who is the younger brother of the. So Mujahidul, the informant, he never went with him. And he makes an FIR saying that I went with the body, things happened, that happened, that.
and he's the brother of the deceased. He's the brother of the deceased.
On being asked Mujahidul, that is the informant, informed me that the body of the deceased is the karate pump. So he was not the karate. He was not in the way.
And
But he gives a statement saying that I carried the body along
He did
with
the-
the vehicle.
and he knows the 9% name, then why he's not immediately lost the FIR after 12
He
hours?
was with the police officer at the place of occurrence immediately after the body was taken in.
Okay, after that, he was crying.
After the event.
After the event, crying, they rushed to the place.
No, by the
They found him to be injured.
yes.
Then he made the die declaration. Then he succumbed. Then they took him to the hospital. On the way, he succumbed.
On the way.
Then
But he-
where was the inquest done? In the hospital?
No, police station.
Police
He
station.
carried the dead body and it is on the way he died. So they turned back the car to the police station, and police station, my lord, it was done. my lord. Even that point of time also, my lord, no FIR was lost. Your lordship kindly say, I'll come to that, my lord. Even
He
they,
did not die on the spot.
on the spot, my lord. They actually, my lord, even a slightest injury in the head, my lord, backside of the head, my lord, people will become unconscious, my lord. In earlier days, my lord, that was a my lord, and like a anesthesia, because there when a person done, there's a giving blow backside, so that my lord, it is at least 2 or 3 hours he'll become unconscious. Here in this case, my lord, your lordship kindly see there is a back injury, there are 2 back injury. Immediately he became unconscious, my lord. So how he can give 9 persons name, that too in a dark night, because who attacked them? So that is absolutely a my lord made up story.
That is okay. See, from the inquest report, it
My
says
lord.
that since the place of occurrence is field without any habitation nearby and
My lord.
provision of light, and it is difficult to hold inquest on the dead body. I taking along Mujahideen
Islam and other
4,
4
5
persons being the
the
dead body
by
by Mount Eco vehicle.
From where?
That is not there.
It was going to the place of occurrence.
And PS lowered the dead body down from the vehicle inside the PS compound. PS
When there
compound.
on the
Police
way, I
station
think he
compound.
met them.
No, he met them at the place of occurrence.
That is what that lordship showed me that.
Was at the place of occurrence. Mujahideen was there. What was his name?
Mujahideen.
Mujahideen. He's there. Mujahideen is there.
Yes, at this one. Page number 53. I arrived at the place of occurrence at 30 a.m. and met the PPT Barakati and showed me one Mujahideen, who is the younger brother on the husband informed me.
They were still at the place of occurrence. They're taking by car and this and that. Someone else took him by the car.
He did not go back.
Brother said, in the case, what is he saying? He took him.
He beated them. But there were some people with him.
That part was taken.
When slightest doubt, my lord.
Have a look into it.
That is one, the other three are there. But there were people because in the inquest report it is said
since the place of occurrence is without any evidence nearby and the provisional right, and it is difficult to hold the inquest on the dead body, I taking along Mujahidul Islam and further bring the dead body
To the police.
by the Maruti 808 with the station to police station.
Where did they bring them? He was injured, he was taken to the hospital. He died on the way. Then the vehicle turned around and brought them to the police station.
In the inquest, it says they together took it. Then again in the evidence, he says he met him. He did not meet the. In the evidence, the IO does not say he met the dead body in the place of. He did not. So he asked him. It was being taken to the hospital. Someone else, but PW1 was not present, as from the evidence comes out. But it was being taken to the hospital, and then he got to know, and he interrupted in the bit. The IO. IO went to the place of occurrence. He did not find the dead body, but he found PW1 who stated that the body is being taken to the hospital.
But that story is not there in the inquest report. It says that
The-
place
yes.
is dark. Place is dark, so we brought the body to the police station compound.
Yes, but the inquest report doesn't say so, but the evidence says.
That is where he was lying. So he was original fact was there.
That is what. The inquest report doesn't say where the dead body is, but in the evidence he says when he went to the place of occurrence, he did not find the dead body. That is the evidence. But in the inquest report, he said they together took the dead. That is what is there in the inquest report. Not
Moved from there to the police.
not because it was taken to the police.
Body was already moved.
Body was already. It was not in the place of.
Which part of the head? From the back.
Back.
The back of the head. So even if there was a hit, the brain may not.
Not
all the crack could have allowed it to flow out.
It's not correct.
The left and the brain.
Because I think the brain will be visible.
The damage.
Damage. Not.
The
Okay, but the thing is, the brain coming out, I think, will be visible by each and everybody, and that is what. If it doesn't come out, the thing that he will be senseless does not arise. Injury later on might aggravate later.
the brain. Yeah.
Then will be within a slight investment. That is why it's very,
It was from the
yes. Study.
But there are four witnesses. There are 4 witnesses stating that they will come.
Made people. My lord, admittedly, in this case, there is no eyewitness.
Sorry?
In this case, there is no eyewitness. In this case, my lord, everything based on, my lord, their circumstantial evidence. The circumstantial PW 1, 2, and 3, my lord. The very circumstance started from by the point of, my lord, phone call. The phone, that circumstantial change is started from the phone call. So that phone call, my lord, there is already a media submission before your lordship. That is absolutely, my lord, humanly not possible, my lord. And just to prove it, they have to, my lord, got the phone call record. That statement of the phone call, my lord, and also not even seize the phone, my lord. So the very initial stage chain is missing, my lord. Very initial stage, my lord. Your lordship kindly sees next, my lord. That was a why I am submitting this is a concocted story, because these things regarding phone call, that's PW 1, 2, and 3, they never stated before the IO. That is clear from the IO evidence. So chain is, my lord, not completed. That is why, my lord, Planet Trial Court, my lord, rightly taking the view, my lord, considering all the evidence, my lord, right from the, my lord, evidence already, my lord, regarding the second, my lord, seconds, my lord, they are very heavily rely on the dying declaration. But dying declaration, my lord, first he has to, my lord, whether he is in a condition to make such statement or not. And PW1 very clearly stated that he was along with him. And when he asks, he says that, the so-and-so kill him. My lord, in occurrence took place in night. There is a dark night. How he can recognize all these 9 persons, even, my lord, assuming that but not admitting that, my lord, he is in a position to speak. Can he, my lord, say 9 persons in a, my lord, in dark night he recognize? So that is completely doubtful, my lord. So sin is missing. And, my lord, doctor's evidence, my lord. Again, my lord, the injury, if your lordship go by the injury, my lord, they are the back side of the head. My lord, back side of the head in the sash, because of that injury, he died. In such injury, my lord, any normal human being, my lord, will be immediately unconscious. So he is not in a position to make any, my lord, statement, my lord. It is and that's why, my lord, Learned Trial Court very clearly, my lord, giving a very right view, my lord. So discarded the dying declaration. Not only on that, only other ground that, my lord, only one he's not in a position as part of PW5 of the medical evidence, my lord. And also there is no light, my lord, that he cannot be recognized. And, my lord, considering this, all this evidence, the Learned Trial Court giving a finding. So now, my lord, in appeal, my lord, from very beginning, my lord, since 1969, my lord, 68, that when there is a two view possible, then court always go for the view which is in favor of the accused. And another judgment, my lord, I will place, my lord, that is judgment in 2012, 10 SCC.
You have a copy?
My lord, I have two copies, my lord. I in all citation, my lord, I have a copy. Para 32, my lord. Para 32, my lord.
This is
Regarding views, my lord. Oh, and now I will cite another two judgment, my lord, regarding the same point, my lord, and same principle is still adopted by the honorable apex court till today, my lord. Page 30, para 32.
I think it's not in dispute.
Not dispute, yes, my lord.
There are two.
Even I'll place another.
Favorable to
My lord.
the accused has to be adopted.
And another judgment, my lord, that is 2019, 2 SCC. And 2021, 3 SCC. Now I'll place, my lord, 2019, then I will come to 2021, my lord. 19, para 18, my lord. This is the judgment, my lord. 513.
Para 18.
Para 18, my lord.
Yeah.
Yeah, that, my lord.
This is also two views.
Your lordship kindly see down, my lord. Para 18, my lord, last sub para, my lord. That the sub para 2, my lord. That is a quote from the another judgment, my lord. The appellate court must always give a proper weightage and consideration to the finding of the learned of the trial court. 3. If two reasonable views can be placed, one that tender acquittal, the other is a conviction, the High Court, appellate court must rule in the favor of the accused. So that is 2019. And same point, my lord, that is 2021, 3 SCC, page 687, para 20, 21, and 22. These are the two. So I will not read that because the same point. So still, my lord, that situation is prevailed, my lord. Para 20, 21, and 22. I sum up my argument, my lord, chief kindly the from basic, my lord, regarding, my lord, circumstantial evidence, my lord. Already, my lord, there is no eyewitness, and very rightly, my lord, learned trial court discard the dying declaration as well as by evidence of the PW 1, 2, and 3. And already, your lordship, some discrepancy already it is prevailed, my lord. Your lordship kindly see. Flashlight was not seized, weapon not seized, mobile not seized, call record not submitted before the court, my lord. And my lord, very interestingly, the person who made the GTN, who know the fact, is the PDP, he is the best person to my lord in this independent case, in this case, who lost the my lord GDN was also not called for. But mine was not seized. And call record not taken. So, your lordship kindly see, and entire circumstance, my lord. Prosecution 14 witnesses. Why they are not examining all the witnesses, my lord? So, what type of, my lord, investigation by the police officer? Because very initial point, my lord, very easily it can be proved, my lord. Because of the call record. Nowadays, my lord, nothing, my lord, hide. In mobile is the best. Call record is the best, my lord, evidence. And which is, I have already submitted that it quite impossible that the hereditary enmity is there. And that man give a missed call and he will come out to an enemy, my lord. And that is riding in the backside of the motorcycle. So that story is, my lord, rightly not believed by the Lana trial court, my lord. So my submission before your lordship, the judgment passed by the Lana trial court is very sound and best possible judgment by the considering the evidence. Not really, nothing to interpret.
Mr. Manta,
My lord.
if the mobile was seized, all records examined, all those lacunas have been like, sort of like
My lord,
completed, then perhaps we would not
let
have
me
the,
know.
we would not have the privilege of hearing you.
Yes, my lord, definitely, my lord. And if it is done, my lord, then, my lord, I am probably I am in the other side, my lord. Then I will, my lord, file a appeal, my lord, against my conviction.
That's all. PP will submit. Okay. Then we'll come to you. You want a reply?
Some point.
Okay.
Yes, Your Lordship, my learned friend has rightly submitted a double presumption against an order of acquittal, Your Lordship, in favor of the accused person. In the case, appeal against the order of acquittal.
You support which side?
No. I support what the case of the prosecution. Still, I support, Your Lordship. Although there are lacunas in the investigation as well as in the trial, but Your Lordship independently assess the evidence on record, whichever was recorded by the learned trial court, Your Lordship, may still rely on the evidence of PW 1, 2, and 3, Your Lordship. Even 6, Your Lordship. They saw the accused person. First, the accused person, Khaza, called the deceased, and then thereafter, he was accused of, the deceased was driving the two-wheeler, and the pillion, Khaza was sitting, Your Lordship. And they were armed with deadly weapons. Although weapons were not seized, Your Lordship, some gun and all of this is right. Yes, Lordship, but yes, guns were seized. And even the torchlight was not seized. I respectfully submit, Your Lordship, that
Guns were seen.
yes.
But there's
that's
no
part of-
gun, there's no gun, bullet injuries.
I don't know, Lordship, the prosecution side season list, the season list. It can be seen, Your Lordship, that yes,
With the,
my lord,
the torch belong to the prosecution.
yes. Torch was not seized. But still, Your Lordship, there are judgments to that effect, even if it is not seen. And even if, Lordship, there are no light, February cold weather, still then the accused person could be identified by the prosecution side on the point that They were previously whatever enmity or they recognize each other. My learned friend was submitting their previous enmity from their forefathers, their lordship. They were killing, but still then, even from their gait, even from their voice, they could be identified. Even if there is, lordship will assume even if there's no torchlight, my lord. And from the evidence of IO, your lordship, might kindly have a look at the evidence of IO, my lord, EW 9. There was delay in lodging the fire, but prior to that, there was a GD entry. Lordship, it was by GD entry was exhibited at page 172. Your Lordship will kindly see the contents of the GD entry. Page 172.
Yes.
Now Muhammad Mubarak Hussain, a member of the VTP of village Bokalibori, Tanasigar, informs over phone that a murder has been committed at village Bakalibori Choto Garjan, accordingly instructing SISC Bora, who is night patrolling, to proceed to the PO over phone. An OC SISC Dole accompanies so and so. So, Lordship, even cryptic information can be, on the basis of cryptic information, the investigating authorities may proceed, my lord. And though there's no infirmity in it, your lordship. So the person, although he was not examined as a witness, prosecution witness, my lord, even on the basis of the GD entry, the investigating authority proceeded with the matter. If your lordship kindly see the evidence of PW 9, my lord, on the basis of the GD entry, he proceeded, your lordship. PW 9.
9 is the IO.
IO, my lord. On 20 to 2012, I was posted at Mayong PS so and so. On the date at about 1:40 a.m., one information received over telephone from VDP member Mubarak Ali Mubarak Hussain that one murder took place at Bakalibari, Chota Garjan. Accordingly, I entered the information in the GD entry by GD entry number 319 so and so and proceeded to the place of occurrence. Then I arrived at the place of at 2:30 and made VDP member Mubarak Ali and showed me one Mujahidul Islam, who is the younger brother of the deceased. On being asked, Mujahidul informed me that the body of the deceased is at Karatipam Chareli in a vehicle, my lord. So by that time, Lordship, Mujahidul, he being the brother, on being informed, your lordship, about the occurrence, your lordship, having coming to know, he immediately was taking the deceased to a nearby hospital, but in between he died. So there possibility that he was in the hospital and he was in the lordship, the dead body was in the vehicle and he came back to the place of occurrence.
She was in the echo van.
Lordship?
IO found the deceased in the echo van.
Yes. Well, that I have not checked whatever, although my learned friend has taken a plea, no, nothing has been stated before the IO. I have to check it, my lord, the records.
Who has done the inquest?
Who has done the PW9? IO, I think, from PW9. Who has done the
IO himself.
Yes, right. Lordship, although it's a case of circumstantial evidence, your lordship, there's no direct eyewitness to it. So in the circumstantial evidence, motive plays an important role. And from the submission from my learned friend, the accused person, motive could be determined because their forefathers have been killed, alleged that they were the perpetrators. This the prosecution side, the appellants or not the appellants, the deceased or his relatives were the perpetrators. So, lordship, motive for the chance that For that reason, there was an enmity, there was a motive, and as a result of which they killed the victim, Your Lordship. Yes, some of the witnesses were not examined as a PWs, but they were examined as a DWs, Your Lordship. But there's no infirmity, except, Your Lordship, they cannot be cross-examined to the statement of, they cannot be cross-examined on the point whatever they have stated before the IO. They cannot be, there's a legal bar on them. Prosecution witnesses can be examined as a defense witness on the call made by the defense, but they cannot be contradicted on the point they made any statement before the IO. On the point, they cannot be cross-examined. There's a legal bar to them. And Your Lordship, there was a oral dying declaration as per evidence of PW 2, 3, and 6, Your Lordship, and even to 1, Your Lordship. So, Your Lordship, I think the defense could not demolish that part. And other aspect, Your Lordship, whether doctor's evidence, there might be, Lordship, little bit of discrepancy here and there, whether it is petty to the prosecution side, my lord. May I submit one judgment, 2016 1 SCC 530, Your Lordship. Munni versus State of MP. 2016,
1 SCC
2016 12 SCC 695
695.
5 or 3 694.
This is regarding
Regarding the doctor's evidence.
paragraph.
Lordship, Manupatra paragraph starts from page para 3. Prachi Mishra, learned counsel appearing for the state, sought to justify the diversion finding recorded in the impugn order by the High Court, placing strong reliance upon the evidence of PW 1 and 8, whose evidence is corroborated with the medical evidence of PW 7, which has been misread by the trial court at the time of recording or finding on the charge. Therefore, the said finding is rightly found fault with by the High Court, and is held that the said approach of the trial court in recording or finding in passing the order of acquittal is erroneous in law. Therefore, the appellate court in exercise of its appellate jurisdiction, after proper reappreciation of evidence on record, rightly set aside the findings of acquittal and held that the charge framed against the accused is proved, and further placed reliance upon the judgment of this court in the case of Umesh Singh versus State of Bihar, reported in 2013 4 SSC 360, para 22, 23.1 and 23.2, in support of the evidence of PW7 regarding the rigor mortis, wherein this court at paragraph 22, after adverting to the decision of this court in the cases of State of Haryana versus Bhagirath, extracted paragraph 15, in which decision this court has held that the opinion given by medical witness need not be the last word on the subject. It would be appropriate to extract the said paragraph in this order, which reads this thus. The opinion given by medical witness need not be the last word on the subject. Such an opinion shall be tested by the court. If the opinion is bereft of logic or objectively, the court is not obliged to go by that opinion. After all, opinion is what is formed in the mind of a person regarding a fact situation. If one doctor forms one opinion and another doctor forms a different opinion on the same facts, it is open to the judge to adopt the view which is more objective or probable. Similarly, if the opinion given by one doctor is not consistent with probability of the court, has no liable to go by that opinion merely because it is said by a doctor. Of course, due weight must be given to opinions given a person who are experts in a particular subject. Then paragraph 4. Learned counsel for the state further submits that the contention asked in this regard by learned senior counsel for the appellant, time of occurrence is totally different, having regard medical evidence. The said portion of the opinion of doctor who was examined in the case need not be the last word for accepting the contention of the appellant and to believe the prosecution. So, Lordship, the opinion given by the doctor should not be the last word of the prosecution. Even the doctor, Lordship, goes to the evidence of the doctor, my lord. PW5, Nothing, at least I could not find anything, your lordship. The cause of death is because of the injury which he has received at the back of his neck. Lordship, page 42, may I read it once? Number one injury was 6 inch into 2 inch into muscle depth. Number two injury was 6 so and so depth. Number of injury 3 is incised and extending from right cheek to middle of lower lip, 5 inch into 2 inch into muscle depth with broken teeth 4 in numbers. Another incised wound extending from right temporal region with middle of the forehead head with fracture of skull. Cranium and spinal cord, brain matter came out in the wound as described. There is laceration in the pleura, right lung rupture. There will be profuse bleeding in such type of injuries. Injury number 2 is situated on the left side of the neck below the chin. In such type of injury, a person come under a neurological shock. With profuse bleeding, there is hemorrhagic shock. Pleura is the protector of the lung which protect outside air. Due to exposure of brain matter, a person immediately became unconscious with shock. The person died within 24 hours of the so-and-so. So, but the cause of death is not expressed in the
20 hours.
yes, my lord.
20
So I'm
hours.
submitting that should not
No,
be the
that
last
4 is not there. 4 is not there. 20 hours.
20 hours.
So once you see 20, that 4 comes automatically. It's 20 hours.
Yes, my
20.
yes. Date of examination is 2 p.m. 2 p.m. on 22. Next day. 22. That open to the next day. Like, same day, actually, yes. But that should not be the lordship. Why to discard the evidence of PW 1, 2, and 6, your lordship? 1, 2, 3, and 6. Nothing to disbelieve, your lordship. And why would they, lordship, implicate? Yes, there are enmities, previous enmities, my lord. At the same time, there was a phone call, although the call records have not been proved. But your lordship, 65B notice which came into existence in 2000, your lordship. I have just seen. Yes, minute. Lordship, 65B came into existence, Act of 2000. Yes, this is a case of 2012.
Which one?
Oh, sorry. I may be corrected, my lord. Yes, yes, yes. That's after, yes, after 2000. Lordship. I may be stand corrected, my lord. Yes, yes. Lordship, when there is,
What is the time of lodging of the FIR?
yes, let us see the chart.
Let us leave the GD entry aside for the moment.
DG,
Just tell us why the FIR was filed on such a type.
The incident took place on 19th at night 11:58.
yes.
The
11,
police received the information somewhere around 1:30 in the night from a phone call
yes,
made by the VDP.
yes,
Police goes to the place of occurrence, meets the younger brother of the deceased.
yes,
He says they are at Keratipam somewhere.
yes,
Let us go there.
yes,
So now the police witness is also there. For the inquest also we can read. The brother, the informant goes with the police to the place, to the dead body, wherever it is, Keratipam or wherever. There they find that it is not possible to
Conduct the inquest.
conduct the inquiry because at Keratipam, not at the place of occurrence, at Keratipam, where the dead body is.
Inside the vehicle.
Whatever, wherever. From there, the brother comes along with the police to the police station.
yes,
That is also there. He's a witness to the inquest. His name is recorded in the inquest report saying that yes, the brother was with us. Then it takes him till 12 in the next, on the next day, on 20th, At 12 o'clock is the first time he says that these are the persons who caused the death of my father.
True, my lord. But
He
your
was
lordship,
there with the police from around 1:30 PM, maybe 2 o'clock, till the inquest was proved.
at the
He
same
was at the
time,
police station.
yes, my lord. Lordship, at the same time, they're the villagers, lordship,
Since-
not the law-abiding
since-
citizens. So much of awareness they
Since
don't
there-
have, my lord.
since that doubt has been created by the accused, that is delay, number one. Then number two, the seizure not being there of the mobiles and anything of the people. Then all the doubts that he has created, we are just trying to understand that if it is doubt enough, with first the benefit of doubt, second the benefit of an acquittal, then it's still going to see whether he can be guilty.
Lordship,
The
Yes,
chain of
you-
events, since you started with circumstantial
Yes,
evidence,
yes,
the
ma'am.
chain has to be there.
yes,
The mobile is not there. Mobile connection is not there. The first chain goes. The delay in the FIR when he was available at the police station at the inquest with the police officer who's investigating the case and he's there in that police station. The delay in the FIR, not about it. If PW1 was the informant and he says that I had moved with the dead body
yes.
in the vehicle and the police says, no, I picked him up from where the occurrence was there and I took him to the other vehicle.
Right.
Given all this, can we find him worthy of any trust? If that be so, the other persons, their statements were recorded by the police later on. How trustworthy would they be? PW6, he named persons who were not named in the FIR, persons who were not there before this statement was recorded. They were added later on. All this, does it make it trustworthy enough for us to uphold your argument of circumstance?
Just because there was delay, lordship and my lord, this brother,
Hmm.
his younger brother or elder brother?
Younger,
Lordship, he expired. Lordship, can you consider his,
elder expired, younger.
yes, my lord. Consider his mindset. At the same time, they are villagers, village people, my lord. They don't know about the ifs and buts of law, my lord.
He's not even explaining his own conduct. He says in his evidence that I went with the body.
Yes.
The police says no, he was waiting there. I took him to the body at the car. Could he
So
be so
I-
confused?
Lordship,
With
on
the
the
body at
basis,
in-
only on the basis of the statement of IO or the evidence of IO, your lordship don't have to, yes, consider. Your lordship has to consider the evidence on record, your lordship. So there are delay, there may not be explanation all the time, whether it is fatal to the prosecution case, there, that your lordship has to judge it, my lordship. So lordship, why to discard the evidence of PW 2, 3 and 6, your lordship? They are at the same time res gestae witness, your lordship, just prior to the occurrence, they were there. Inquest he was much, he was there, my lord. At the same time, lordship,
All the time. That's circumstance. Not because there is a delay. We are not saying that
fatal,
with some doubt. No, we will not can doubt it.
my lord,
at times.
my lord.
But in this particular circumstance, all the time. No need.
Let us see what they have stated before the IO once. Whatever they have stated before the IO, let us see once. No, 161, your lordship. Just prior to the occurrence, they saw this one of the accused. I don't know why they have filed appeal against acquittal only against one person. Maybe he was very much there. He was witnessed by
Yeah.
witnesses. I know. Lordship, they left. Sir. No, no appeal. I have no
You're writing
information.
on his appeal. You're not filed the independent appeal.
Weapon not seized. At the same time, some bullets were seized, my lord. Bullets and other It was says.
Ms. Bhia, who takes a decision in filing appeal in such a way?
Lordship.
You have a director of prosecution.
Yes, yes. Nowadays it's directed.
They look at-
Yes. Sometimes it comes from the districts, my lord, or districts, they give the opinion. Like we need to file an appeal because the learned trial court has not taken into account that evidence and record correctly. So in the event of the matter, we'll file.
It hasn't happened in this case.
I lordship no information. Yes, yes.
Writing a letter means, writing a letter means just enclosing the judgment or giving an opinion. Some comments also.
He's not even an.
Maybe it was also there. No, as a result of the stab injury, he subsequently died. So there was lordship, no use, like it was lying with them.
In another case, it at page 14,
Page 40,
page 14 case was that, right?
my lord.
He is the informant there. It has been recovered from him.
Jalil.
Jalil.
Hey, Jalil.
Having a very severe negative mind of it.
This is the other case, the murder.
The weapon recovery is from this informant.
This is
The
the
investigation
Jalil.
case, they go and recover from him.
Jalil Molvi, A. Jalil Molvi.
case.
Another better.
He is not even involved in page 2. Have you looked at page 2?
Abdul Jalil is there.
Right.
9, my lord. Page upper. Yes, yes, my lord. 9. Is there. On the point, the plea raised by my learned friend as regards non-seizing of torch, whether it is fatal, may I cite one position, my lord? SCC, may I cite? 2002, 5 SCC 323,
Regarding
regarding non-seizing of torchlight. There are 16, my lord. PW, para 15. For acquitting the accused, the High Court has held that PW1 cannot be relied upon as he had not disclosed the names of the accused person to PWs 10 and 13, whom he made immediately after the occurrence. Finding that PW1 was proved to be a coward who did not come to the rescue of his wife, the appellate court rejected his testimony. He was found contradicting his own testimony when he allegedly stated that A5 has stabbed his wife, which has also stood contradicted by the medical evidence. The testimony of PW1 did not find favor with the High Court on account of non-seizure of the torch by the investigating agency. The High Court found that the view taken by the session judge regarding the perfunctory nature of the investigation was not acceptable, which entitled the accused to be acquitted. The views taken by the High Court apparently appears to be perverse, not based upon evidence, completely in negation of the normal human behavior of an individual caught in such a horrifying situation, and forgetting that for the fault in the investigation, no benefit can be given to the accused person. The findings of the session judge that the investigation was perfunctory is based upon almost admitted facts. The Frequent chains of the investigating officer prove beyond doubt that the initial investigation was tainted in favor of the accused, apparently under the influence. It is only when Dhaneshwari Patti DCP, Crime Branch, PW 41 took over the investigation that some evidence was collected to find out the truth regarding the allegations made by PW1. Non-disclosure of the names of PW1 to PWs 10 and 13 could not be made a ground for rejecting his testimony, as it was in evidence that the said witness was under a shock and the aforesaid two witnesses did not inquire from him names of the accused person. The efforts made by PW1 to reach the police station during the night peak of his sincere effort, and it goes in our against us, no? To ensure that the real culprits were brought to book. The making of telephone call by PW1 has been admitted by PW19. However, the conduct of the officer in charge of the police station by not responding to the telephonic call or to reach on spot is regrettable. Many questions arise regarding the conduct of the police, particularly when the accused persons are shown to have reached at least Jagat Singhpur to influence the police person. It is regrettable to note that the officer in charge of police station directed PW1 to delete certain portions from the written report. There is
No explanation.
There's no explanation as to why the signature were obtained on two blank papers. Only because PW1 could not save his wife did not warrant a finding that he was a coward and should not be believed. Then, Lordship. The circumstances narrated by the aforesaid witnesses show the presence of a number of accused persons, some of whom were even armed with one knife. He had the infant child in his lap and heard the deceased crying and appealing to PW1 to save his life and the life of the infant. By no standards of PW1 can be termed to be coward under the circumstances. Even if he was a coward, there is no ground to not rely upon his testimony on that ground alone. Failure to the police to search for the torch and seize this, particularly when the investigating agency was found to be under the influence of the accused person, could not be made a ground to reject the otherwise self-inspiring testimony of PW1. We are satisfied that the present case is a fit case requiring an interference, as the High Court has failed to discharge its statutory obligation. The accused have wrongfully been acquitted on surmise and conjectures, ignoring the trustworthy evidence of PW1 by reaching at perverse conclusion regarding the factors of the case. And your lordship, one of the another factor, last seen theory, your lordship. Last seen theory, the accused person, this Khadim, was found driving pillion with the deceased, your lordship. And immediately thereafter, the occurrence had taken place. And so the time gap is too small, your lordship. In that event of the matter, your lordship, that last seen theory will also come into play. And another submission I'll take as regards section 114 of the Evidence Act, your lordship. Presumption, no? Lordship, section 114 of the Evidence Act. Court may presume existence of certain facts. The court may presume the existence of any fact which it thinks likely to have happened. Regard being had to common course of natural events, human conduct in a public and private business in their relation to the facts of particular case. Then there are illustrations, my lord. Lordship G, my lord. That evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. And in 313 statement also nothing, no explanation, nothing. Only denial, your lordship.
Clear?
Lordship.
Anything else?
Lordship, on the point of 149, may I cite one Jasmine, although I have not given the citation, I'll give the reference 2010-13 SCC 409, who has gave the fatal blow on the deceased who are the perpetrators. In the case of 149, that is not required. Anissa? Para 12, madam. Lordship, para 12. We do not find any substance in the submission of the learned counsel. In our opinion, the common object of an unlawful assembly has to be gathered from the nature of the assembly, arms possessed by them, and the behavior of the assembly at or before the occurrence. It is an inference which has to be deduced from the facts and circumstances of each case. To attract the mischief under section 149 of the penal code, it is not necessary that each of the accused must commit some illegal overt act. When the assembly is found to be unlawful and if offense is committed by any member of an unlawful assembly in prosecution of the common object, every member of an unlawful assembly shall be guilty of the offense committed by another member of the assembly. It has to be borne in mind that an assembly which is not unlawful when assembled may subsequently become an unlawful assembly. Lordship will kindly note one thing. They were witnessing some jatra, my lord, some function. But at the same time, they were equipped with arms, your lordship. So, lordship, their object, their intention can be gathered, my lord, not the intention, their object could be gathered from the weapon of assault, although that were not seized and something else was seized, your lordship. So they were like witnessing chatra. Would anyone carry weapons of offense, your lordship? So summing up, your lordship, may I submit, your lordship, the prosecution could prove the case beyond reasonable doubt, but at the same time, the learned trial court did not appreciate the evidence on record and acquitted the accused person without considering the materials on record. And in the event of the matter, your lordship would kindly interfere with the order of acquittal. That is my response.
Lordship, regarding the place of occurrence, there is one place of occurrence, and thereafter, some people took the dead body towards the hospital. In between, he passed away. They stopped the car. That is from PW 2-3. They state so. PW 2. They stop the car. They call the police, and the police, they go to the place of occurrence. They do not find anybody, as rightly pointed out by your lordship. PW 1 was there. Then they go to that spot. That will be clear from PW 2. PW 2, page number 27. Okay, 6 lines from below, just above the cross. I have seen cut injury on his forehead, chin, back, ear, face, and the nose, and on the back side of the head. I informed Baharul to bring the vehicle for carrying Moinul, that is the deceased, to hospital. After a while, Jainul arrived with a vehicle, and we took Moinul into the car and proceeded to Morigaon Civil Hospital. But after coming about 2.5 kilometers, Moinul succumbed to his injuries. So we stopped the vehicle at Karatipar, Chariali, and informed Mayang police station. Thereafter, police arrived at Charali and took away the dead body from there. So all these people, they went, but rightly pointed out by your lordship, PW1. Now PW1 also states that he went, but the IO states in his evidence that he went to the place of occurrence first. There he did not find anybody except one VDP member and the PW1. From him, he got to know that the dead body is being taken, sorry, the disease is being taken to the hospital. And he goes to the hospital towards that track and he finds the car there. he comes to the conclusion the inquest cannot be done there. And from there, he takes the car, he takes the dead body and he goes to the police station. And in the cross of the IO, he states that around 4:10 a.m., he reached the police station. After that, the inquest was conducted. All the formalities were done. So the delay is not of 12 hours, as stated by my learned friend. Till 4:15, he did not even reach the police station. That is from the IO's cross. Page number 50. Page number 54, the cross portion. 7. I came back and arrived at the police station at 4:10 a.m. So 4:10 a.m. he arrived at the police station. We know the inquest was conducted in the campus of the police station. So the inquest was conducted, all formalities were done. Thereafter, he again states, it is not exactly at 12 noon. On that day, at about 12 noon. So at about 12 noon is very subjective. It can be 11, it can be 1. So at around 12 noon, till 4 o'clock, he just reached there. He completed all the formalities that can take normally around 2 to 3 hours. And thereafter, so there is a window of 5 hours. So 5 hours delay. That is the most that can be said here. Moreover, my learned senior friend has stated why the prosecution witnesses were not, why the witnesses stated in the charge sheet were not arrayed as prosecution witnesses. They have come up as DW, but they do not speak loud about what had happened. So rightly, they were not given as prosecuted witnesses, because what they have stated, they have not stated anything about the occurrence. They only saw a person lying there. They thought it was an accident. That was only what the information was passed by the DWs. So rightly, they did not know anything about the incident. So they were not made a prosecution witness later, though they were cited. There is no bar on not why they were withheld, but because the information that they had given after becoming DW does not help any of them, neither the prosecution nor the defense. And they have stated about an accident, but the injuries stated by the postmortem report, those do not come in an accident. It was very specific, the postmortem report. Cause of death, hemorrhage, shock as a result of multiple injuries caused by sharp cutting weapon. It is very specific. So the DWs were trying to portray as if an accident had happened, and they saw a man lying there. An accident has happened, and he succumbed later. But the postmortem is totally opposite to it. And another aspect, the injury. The injury was caused from where the brain was visible. That is page number 160. Point number 2. Incised wound extending from the right temporal region to middle of the forehead. So that is in front. So the persons who first hit him, obviously some brain portion coming out will be visible to them. That is page number 160. External appearances, postmortem report, external appearances, Roman 1, below, point number 2, subpoint 2. Incised wound extending from right temporal region, because this is the wound that the medical evidence is stressing, for which he can become unconscious.
Temporal region
To the middle of the forehead.
Temporal region is
I believe this side, Lordship, right temporal region, and to the forehead. It's coming towards the forehead. So there were injuries in the back, but from the brain that was visible was coming from this bone, this injury. Brain matter exposed. So ultimately, it comes down to the dying, and also, as your Lordship said, the circumstantial evidences. The chain, if the dying declaration is good enough, if it is trustworthy, corroboration is not required as per law. But it is a prudence of law that corroboration may be there. The evidences say so. And secondly, motive is there. In circumstantial evidence, motive plays a very important part. Motive is apparent here because he is accused in my father's murder trial. So the motive is very much here. The FIR of that case has also is here. So the thing only about the delay of 5-6 hours, and that too 5-6 hours delay, how much will it affect such case, and how much confidence do we have in the evidence of the PWs? as rightly pointed out, PW1 does state that he went, but from the evidence of IO, it comes to light that he was present in the place of occurrence. He did not. But PW2, 3, and 6, they went, they are corroborating, and their evidence is still there. It was never demolished by the defense. So again, it comes down to, do we believe in their evidence or not? If not, why should we not? It was never demolished. It is based on a dying declaration. Now we come up to the dying declaration. Can that be a source of conviction? Yes, it certainly can, but provided it inspires confidence. So that comes with now the doctor's evidence. The doctor says he will become unconscious if that brain exposure is there. But in the inquest and the witnesses who went there at the first point of time, they do not say regarding any brain coming. So that is a very important aspect which they should have stated, and they haven't, because it was not there. Subsequently, due to the passage of time, some injury might aggravate, it might become graver, and that is visible later on, because the inquest is done admittedly after more than 12 hours at 2 p.m. Incident happened at 12 or 1 o'clock early night. So at that time, that was visible. So the doctor came to its finding, if that injury he will become unconscious, which if he was unconscious, rightly he could not have stated the dying declaration. But now when there is a conflict, contrary in the ocular evidence and the medical evidence, which one should we follow? And Learned Senior Plaintiff already passed a judgment. I also had given. So it is when it is well settled if there is a conflict in the ocular evidence and the medical testimony evidence, it is the ocular evidence which will prevail unless found to be totally unreliable. Then again, in the aforesaid, the court has consistently accorded greater weight to ocular testimony than to the opinion of medical experts. So again, ultimately, it boils down to that same point. Do we believe this dying declaration or not? According to me, the dying declaration is trustworthy, and it can be the sole basis of conviction. The defense never demolished the evidence that was there in the record. It still exists, and it will, because it was never demolished. So, Lordship, that is my case. I believe it is a fit case where your Lordship should interfere with the acquittal order. And regarding one more point, my learned, there was no light. And why they were going to the direction, as normal human being, direction towards where the public was there. Assuming there was no light, they believed they could not be seen. But they were going wherever they wanted to their destination. As there was no light, they thought they will not be recognized, assuming there was no light. So they were going to the direction, and they happened to cross by these witnesses crossed, and they have seen all these accused crossing with sharp weapons. And there was a murder, admittedly, because the postmortem report says so. There are so many injuries. It cannot be an accident, and cannot be on thin air, those injuries that come out. Somebody has done something, that is true. But unfortunately, the trial court acquitted all. But going by the evidence on record and the dying declaration, I believe your Lordship should exercise the power and interfere with the order. I respect it.
Lordship, one point I had left out regarding section 6 of the Evidence Act. Relevancy of facts forming part of same transaction. Lordship, the witnesses, they have seen the accused person just before and after the occurrence. There is no time period, Your Lordship. Even the last scene, as well as the principal res geste, will come into play, Your Lordship, because it is contemporaneous to the incident which had taken place. Relevancy of facts forming part of same transaction. Facts which, though not in issue, are so connected with a fact in issue as to form part of the same transaction are relevant whether they occurred at the same time and place or at different times and places. So these witnesses have witnessed this acquitted accused just prior to the occurrence and after the occurrence. So the evidence, Lordship, is an exception to the hearsay. comments, your lordship may kindly see hearsay evidence. For bringing hearsay evidence in the ambit of section 6, what is required to be established is that it must be almost contemporaneous with the acts, and there could not be an interval which could allow fabrication. In other words, the statement said to be admitted as forming part of res gestae must have been made contemporaneously with the act or immediately thereafter. Lordship, may I reiterate my submission, my lord? Considering the entire evidence on record, your lordship independently assess the evidence, and so that no innocent person is punished, and at the same time, no guilty should be set free, your lordship. That your lordship has to judge. Obliged.
Okay, we'll consider. Right. So, Mr.
VH Chaudhary. Behalf of Mr. A.M. Bora.
Sorry?
On behalf of Mr. A.M. Bora, VH. VH Chaudhary.
Yeah. You have not executed your power.
Lordship?
You have not executed your power.
No, Lordship.
Yeah, Chaudhary. Please write alert, Mr. B.H. Chaudhary. ये मात्रा actually justified. Or point number one. This one,
R2, R1 is a state, no?
but it's written Khaja Alom and another. Firstly,
Memo, State of Assam and Mohammed Khaja Alam. One meeting. Ikaw na ko electing us.
correspondent number one and P. Bhuyan and an additional PP Assam for respondent number two. Parties have made their application.
Assisted by R. Saloy, my. R. Saloy.
P. Bhuyan and assisted by this
R. That's it.
R. Saloy.
PP of it.
Why do you think?
I appear on behalf of Mr. A.M. Bora in item number 5, Lordship. Can it be taken up some other day, Lordship? Can it be next week, any day, Lordship, on a hearing day? 5 and 6. Consent has also been taken. We have informed
You
the
appear for the appellant.
appeal in item number 5.
Then what about 6?
It's a lot, 0.6 and. That's largely.
Can it be on next week, any day as per your Lordship's convenience?
That would be covered.
If it's 16. Can it be before 16 or any day after, not 16? It,
The lordship not on 18, your lordship. Another day.
23rd.
23rd, your lordship.
23rd.
23rd.
Yes.
But
Oblige.
Need please lordship. Lordship, around 13 witnesses, I won't be able to complete. Sometime next week, possible, my lord.
Next week might be difficult.
But maybe 16th or 17th, if it is convenient to your lordships.
The 40, 43.
My lord, if
Appeal is of the year 2022
2022,
and conviction of which year?
22, my lord.
that's why your lordship convenient.
Parties have to be ready for that point.
Well, I'm ready, but
We can even take, but after the parties are ready to gain.
Any day, my lord. Otherwise, my lord, otherwise, this matter will take time. Actually.
All the matters are like that.
Yes, my lord.
At least 7, 8, 10, 15 witnesses.
Yes.
For the case. One day. That's the case.
16th. Oblige.
Okay.
Ultimate.
Maybe, in this case, man, there are more than 10 witnesses, man. There are some contradictions where there are 161 statement, man. It will take some time, man. Initially, in the FIR, 5 persons were named. 3 were already acquitted, 1 expired. They do fire between 2 groups, man.
We have a date after the summer. Okay. Okay.
21 summer.
Seven. Yes,
May please, my lord. Yesterday, one IA was filed, my lord, which has come in the supply list, my lord, which is connected to this instant appeal, my lord. May I kindly have a look at the IA, my lord. The IA was filed under section, my lord, 432 of PNS, read with, my lord, 348 of PNS for taking additional evidence and recalling and re-examination of the witness. My lord, the appellant herein, he was, my lord, convicted under section 6 of POCSO, my lord, and he was sentenced to undergo, my lord, rigorous imprisonment for life.
yes. So what is the additional evidence that you?
My lord, additional evidence, what has happened, my lord, the informant of this case, my lord, prior to lodging this instant FIR, she lodged another FIR against another co-accused, which was also registered under the provisions of POCSO Act, my lord. What has happened? It is alleged in the instant FIR that on a certain date, that is 28/6/2018, The accused applicant herein is alleged to have committed rape upon the victim for the second time. Interestingly, on that very day, the informant goes to the police station and lodges FIR against another person.
That is not on record.
My lord,
That is not on record. In the evidence.
but that is on record. But only this aspect has come on record that during cross-examination of PW 1 and 2, only these questions were put that he has admitted that yes, I have lodged another FIR against another accused person. But entire evidence could not be brought on record as because, my lord, at that on the date of
This came to light on the examination of PW1.
my lord, after examination, because my lord, on the day when the evidence was recorded in this instant case of PW 1 and 2, by that time that FIR was under investigation, my lord. So I could not even procure the certified copies. My lord, may kindly have a look.
Where have you stated that? In your application.
My lord, in the appeal, I have prayed for calling of the case for that case as well. The other co-accused.
No, we are seeing the application.
My lord, this IA, my lord.
Yes, I am.
Para 5 and 6, my lord.
Lordship, may I respectfully submit a copy is not available with me.
Copy to my TC they can do better.
Copy?
আপোনাক তো মই ৰেছপণ্ডেণ্ট নম্বৰ 2 point দিয়া না আপোনাক মই দি দিম ৰিচিভ
Lordship, I don't know whether they have sub copy on me, but they have to sub copy on the informant or victim, informant. Informant.
There's a seal of the public prosecutor. Copy was given to you, but not the information.
Oh no, on you, the litigant, their potential is there. On the same day, another FIR was lost, it is somebody else. So so later copy piece up on him also. We'll verify which is that.
Yes, please. That will be the.
Yes.
I'll furnish a copy to the learned amicus curiae.
Later may come up on Monday or Tuesday.
Order.
I can.
You have a look at the application first. This time is required to grant. Otherwise, we'll post it on Tuesday.
Tuesday.
Number to go.
Not Mr.
P. Jain, man.
E.J.
Jain.
E. Jain Learned Counsel for the applicant. That this application is filed by the applicant under section 432 of the BNSS 2023. Praying for a direction to the learned special judge also Gauhati for taking additional evidence of PW1 and PW2 and to recall and re-examine PW1 and PWP in POCSO case number 21 of 2018. This be additional public prosecutor. With that, she may be given some time because the application has not been given to her by the office. And likewise, Mr. B.K. N. Borwa, learned counsel appearing for, you're the amicus. learned amicus curiae appearing for the informant. Also submits that he has not received an opportunity.
But I'm furnishing the copy now itself.
One copy, Your Lordship, I'm informed by our office, like, lying there, no.
You have a copy.
No, sorry.
Considering the same, that the matter be listed again on Tuesday. Give the date. None. This is 11. Hold it. It's on 11. The learned counsel for the applicant has handed over a copy of the IA to Mr. N. Barrow.
Deeply obliged.
This is what 302. Who's the appellate? Counsel is there or am I just kidding? Appeal against the conviction or acquittal? Conviction. Conviction. Yes, for the appellant. Other person. Yes, for the state. Okay. So,
18 meter.
Sorry?
Sir, 2018 meter.
Till the matters of the year 2008, learned counsel for the appellate. The learned counsels for the appellate will make an endeavor to conduct case by the victim.
Item one for orders.
Madam Legion Lordship. Respondent for file have, respondent for file the affidavit reply Lordship, opposition Lordship. So I may be allowed to file affidavit reply Lordship.
When was it filed?
On 2nd May 2026.
Respondent number 4.
Or second June. Sorry.
Headmaster. I am for the respondent number 5. madam.
Headmaster file opposition.
Is there any counsel representing him?
Yes, Lordship.
Yes, earlier Mr. Pavitra Sekia.
He said,
Pavitra Sekia appeared madam, earlier. So he has filed the affidavit. So
He appears for respondent number 4 only.
yes.
yes,
He is filed affidavit.
yes, Lordship.
Is it available?
2nd of June.
Second, today is 4th. Bharat may not be available in the record.
Not available. Because the report says that the office note says no affidavit has been filed, has been received from respondent number 1 for till date. This is dated 2nd of June.
On the same day filed. Same day he have filed.
He has filed.
Yes. Already filed, Lordship. I have received.
Maybe he gave you an advance copy, but whether he has filed or not, how would we? He's not come today. Mr. Please, I can.
Not before this court.
He has not seen.
Okay.
Your good name.
GG Gogoi.
You have given a copy. You have a copy.
I have not provided with the copy, my lord.
I have received, Lordship.
Huh?
I have received, Lordship. He has served me copy.
I am for a respondent number 5.
Mr. G.G. Gogoi, learned counsel for the review petitioner.
Yes.
Submit that he has received a copy of the affidavit in opposition.
Yes, Lordship.
Filed by the respondent number 4. And therefore you would like to file a rejoinder to the same. Now, it is however seen that copy of the affidavit of position take the filed by respondent number 4 is not available. The counsel for respondent number 4, Mr. P. Saikia, is also not present. But Mr. N.K. Padita, learned counsel for respondent number 5. With that, he also has not received a copy. He has not received a copy of the evidence of the said to have been filed by respondent number 4. Now, next, I will give office to verify and connect the affidavit said to have been filed by respondent to the report. The petitioner may file return affidavit as paid for which, how much time?
1 week's time.
A week's time is practical. The respondent number 4 can also furnish a copy of the affidavit that they have been filed to the take part.
Before vacation, my lord. Vacation will start from 26th.
I think we have to the
Well, actually, my lord, due to the revision, the tendency of this revision, my lord, I am not able to, my service is not able to regularize. Lordship has already directed to regularize my service in the year 2023 itself. So kindly let us have a try, my lord.
The reason is this bench may not be.
Yes, Lord, yes, Lord. I understand that.
With that case, we'll have to take it to VC or
As per your lordship's convenience, then,
Immediate after vacation, when Lordship is available.
because revisions otherwise review, so lordship has to be there.
let's discuss the matter again after the 3 weeks of the meeting. As and when this bench is available. Liberty is granted to the parties, make it a change.